district officer.
The executive.
Logic.
Then principal magistrates, we have said that they have discharged dual functions. They are the CGM and they are also the JJB. So unless you provide up-to-date infrastructure, nobody will go. If I ask you to be in your office of the government advocate, senior government advocate, with only with a table and chair, I find it very difficult to cope up.
Correct.
These are the issues which when we spoke to people, this is what we arrive at.
If your lordships can hear me,
Yes.
in fact, your lordship is absolutely right. As far as Karnataka is concerned, this was the same problem as far as JJBs in Karnataka also. So Justice Oka, as he was then, passed a detailed order requiring all the JJBs and the CWCs to have complete infrastructure. And pursuant to the orders of the Honorable Court.
You can share the citation with Mr. Chaudhary so that he can give it to us. We'll have the
I will, Manoj, immediately. I'll send that order and mark that particular portion.
We'll take this up in the next hearing.
Very good.
But
Today there are single bench and
what Malad, I have Malad, from the discussion with the secretary I got. Malad, in paragraph, in fact, we have 11. We have stated that we have already shared the draft child protection policy as well as the draft rules. Malad, draft rules
that's
we have
okay.
annexed here with the Bachman Bachao Andolan. Malad.
No.
They have also Malad
Yes,
agreed
Manoj.
that
That is
they
absolutely right. We are assisting them.
They will provide us the model rules because they have already drafted for some other states also. Malad,
no, we understand. We are not saying, we are not committing anything adverse. What we are saying is that if it is taking time, please have it circulated that at least the draft model rules should be followed.
that will be done. Malad. That will go.
Because it is interlinked with also this education. And we were thinking
Correct.
few moments back that at least in this what you call this JJB team which is there, the government should also think to include the education department when we have the stakeholders meet and all, because of the fact that you are also required to give them education. Now in the last meeting it turned out that we also have to have infrastructures for the disabled. So this some additional departments are required to be added in this core committee so that the government can work in tandem with all these departments. So please identify, Madam, you please identify those departments like for disabled, we have to have some people from the
social justice, social
justice and then especially the medical, and then rehabilitation would also require some sort of persons. An education department to give them education.
Health education and social justice.
Please try to identify this.
Done convergence meeting with the line departments.
It's done.
Yes, we have conducted line departments meetings for that.
Okay, tell us about today's issue. We understand sum and substance. Let us not lengthen the matter. You have not been able to finalize. There are some defects. There may be, according in your opinion, there are some maybe contradictions, contraventions with some statute. Okay, accepted. When?
But we have shared it already with the Bachman Bachao.
No, how much time more?
They have some expertise. I would request my my learned senior.
Don't put the ball into others' court straight away. You also do your part.
They are doing. Let them also. If they respond to us, it will help us. That will do.
No, you assume the negative. Let us say Mr. Sharma is not assisting you. We doubt it that he will not assist you, but let us assume that he will not assist you. Then, but the state must go ahead.
That's true.
So that's why we are asking how much more time.
As regard the child protection, the policy, they expressed, the secretary, I talked to him specifically, he said that 1 month time is required for the child policy. And for the rules,
instead of 1 month, we are giving you 2 months time. But do it.
Or we can adjourn the sine die until and unless you come with make a mention.
No, but I would not.
We'll adjourn it sine die. You make a mention at your own pace. You do things and come back to us.
That I would not.
That is a better proposition instead of wasting almost 15 minutes of judicial time we have spent today almost half an hour we spent yesterday, two judges which are not shortage of work sitting here. So we'll make a mention whenever you are ready, we'll sit as per your convenience. I think that is better, Mr. Nath.
But,
No, because you see, there's another aspect. If we two sit and don't do any work, that against, when we introspect, we find that the time is wasted.
No, my lord, I would humbly submit, my lord, that the time is not wasted, my lord. In fact, the position we have expressed, my lord, lordship has considered it. But on discussion, my lord, on
No,
instruction, I
that's fine.
submit.
We are not going to back
Lordship.
to your position.
Lordship.
What is our concern is
But it is-
that from the past, what we have seen that this position continues for quite a long time. So we cannot decide the time. And what the time you propose is fail. So therefore, we'll give you everything to you and make a mention. We'll come back
But, my lord,
at your own
it's only a-
space as
it's only a policy.
as your will. At your will.
It's only a policy.
And we'll have to report this, the affairs of the state in the next meeting. This is going to be happen in Pan India.
My lord, we have expressed the reasons, my lord.
That
why-
is
why it
our idea
why it
was that at
why
least
it
we
was
can
not- why
place
it could not be, my lord.
before the whole of India in the next meeting, saying that they see we are one of the states which we are having the everything on place.
That is, of course, my lord, not.
So we'll have to
Not-
say, no, it's a failure on part of all the monitoring bench as well as on the state. We have not been able to convince you.
But let us come up with the
Because we
policy, my
wanted
lord, and
to-
the
we
rules
wanted
also,
to
my
say
lord, we are
with
doing, my
pride.
lord.
See, what my brother is indicating, we wanted to say with pride that at least in this state, something has happened.
But I fully agree. with that.
If you don't feel proud in saying something,
My lord.
better not say anything.
That is what I said.
We're giving you 2 months' time, we do it. But
May I make a suggestion, Manoj, if your lordship? Lordships will just keep one date. I understand judicial time is wasted in this exercise because we will give our comments in about a week time. The policy, they are saying it will take about four weeks, Manoj. Let's keep it because I don't want after 2 months, again, some time is taken.
no, because it goes against 2 months, it will go because then again in October, there's a vacation.
Yes. Oh, I understand. Of course.
It also has to go.
Yes, of course.
Certain things to have precedent, pujas and all.
Yes.
Then only we can go back to do all the work.
Of course, Manoj. of course.
Yes.
Regarding Lordship, Juvenile Justice Board Lordship, we have received the instruction from Registered Lordship, District-wise Lordship.
You give prepare a note and circulate it, then we'll take on the next date.
You give a copy to
Including
them
Mr.
also.
Sharma.
Yes, Lordship.
Give a copy to them, Mr. Chaudhary also, so that he can send it to Mr. Sharma.
Lordship.
Just indicate the names.
Lordship.
Officers present. So present. Mr. D. Nath, the senior government advocate, has referred to the affidavit filed on 12/9/2024 and submits that about 1 month more time we will be consumed in settling and notifying the rules as well as the child protection policy.
Well, the policy, I said, the rules may take some more time. The child protection policy, 1 month, I said.
Okay, child protection policy and the rules to be framed by the state would take some more time. We hope that in the absence of the child protection policy and the state rules in place, the state would inform all the stakeholders that till the child policy and the rules are framed by the state, all stakeholders shall follow the draft model rules, draft central model rules. 2016, right? 2016, proprio vigore. Next para. The registry has received a note from the Judicial Academy Assam indicating the various challenges faced by the juvenile justice boards. Full stop. The said note dated 5/9/2024, along with compilation of the issues and challenges faced by the juvenile justice boards, be circulated to the learned counsel for the appearing parties. So that the state can take steps for redressal of the various issues and challenges faced by the juvenile justice boards. However, the same shall be taken up on the next date. So the said note shall be taken up by the court on the next date of listing. Next para. Mr. P.P. Sharma, Learned Counsel for the petitioner Bachpan Bachao Andolan, has submitted that they have received the draft child policy from the state and necessary inputs would be provided to the state within a week. Next para. Just put on record our hope and trust that the state government, with all its resources and might, would take immediate steps so as to notify the draft child policy, as well as to notify the rules, so that the purpose of the Juvenile Justice Care and Protection of Children Act is achieved in the state. Post list on, give a date after 2 weeks, after 2 months. On 5th of November 2024, subject to availability of the bench.
Well, we have also shared the rules, draft rules. In fact, in the affidavit, we have annexed the entire copy. I would request
So is the draft rules shared, huh? But do it fast. Because we don't want to sit and again take back a sorry figure.
We also not feel very good.
Because if we are the implementing bench, if we can't do anything, we'll have to report it to the Supreme Court that we have failed. And to expose our failure, come back upon the state.
Correct.
because we can't do anything ourselves. Unless, of course, the government of Assam gives us the license to kill James Bond. If you can give that license, then implement.
Chief may not like to take up this matter. 7. Deeply. Or on Monday, if it's convenient on Monday. Deeply.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item numbers 12 and 13, my lord. In 12, I am the respondent, number 3, and 13, I am the petitioner. Yes, my lord, already recognized. Kindly, my lord, 12 and 13. Kindly pass over for them.
12 and 13. Okay. Pastor of the day is prayed for by and counsel for the respondent
In
number
12?
3 in criminal petition 1301 of 2023.
Obligation.
May it please the lordship. I beg to mention item number 50, lordship. Madam, I adjourn for a week, lordship. I am for the petition.
50. Okay. Just after a week is prayed for by and counsel for the petitioner.
The interim is there, lordship.
Okay. Interim order passed earlier stands extended till the next date of listing.
Obligation.
May it please lordship. Lordship, I beg to mention for listing.
Listing, make a prayer tomorrow because this is not a on Monday because this is not a regular bench. Correct?
May it please your lordship, I beg to mention item number 18. My lord, may be adjourned for the day.
18. You have taken consent of the other side?
My lord, the other side is the bank.
I'm not concerned who if there is a bank or is I've just asked you whether you're taking consent.
My lord, the consent is not been taken.
Then
Last,
no, there's no
according to
adjournment.
last order.
No adjournment ex parte. Next.
My lord, according to the last order, we were supposed to service.
That we don't know. No ex parte adjournment. You should have courtesy to inform the other side when you are praying for an adjournment. Would you like to stay for the entire day and 4 o'clock you come to know that the matter has not been taken up? Would you like it?
No, my
If you like, then you file an affidavit when we'll adjourn this matter. File an affidavit, then in your cases, no consent is required to take an adjournment. We'll circulate it to the registry and then we'll proceed. No, please don't do that.
Much of it.
You must extend the same courtesy to the others which you want yourself.
Yes, ma'am. May I please look? My lord, item number 35, perhaps CS submitted, my lord. I will approach before the learned code below, my lord.
35.
35.
Okay. Both sides are represented. Mr. S.S. Boral and AVP submits that FR has been submitted.
CS, sir.
In this case, being FR number, Huh?
Right, CS number 52 of the 2024.
I'm not hearing you. Please say loudly.
Charge has been filed. Or survived.
Charge sheet has been filed.
Yes, Lordship.
Okay, charge sheet filed in the matter. Stop. Next para, accordingly, Mr. Paramedic and counsel for the petitioner. Please, with that the matter be closed and as he would exercise his right to move the trial court or bail. First of with the said liberty, the matter stands closed.
Highly obliged.
May I please your lordship? Lordship, with regard to item number 51, we have come to know from the official website of the e-court that the petitioner has engaged some other advocates, lordship. So lordship, without obtaining NOC, they have engaged some other advocates.
Item number
51, lordship.
51.
Yes.
Okay.
Ship.
Okay, we take a note of it. Pass orders accordingly. Your name?
S. Paul on behalf of Mr. A. Bhattacharya, lordship. So we may be allowed to withdraw our vakalatnama from the instant case.
No, that verbal permission can't be granted because under High Court rules, you'll have to file an application, then we can permit. But we'll take note of it if the other side, if other counsel comes, we'll pass an order to exonerate you. Okay. You have
What
made
of
an
this
order.
one?
May I please your lordship, item number 22, with the consent of other side. As the matter of 2 weeks.
22,
Lordship.
with consent of the other side,
Yes.
the counsel for the petitioner pays for adjournment. Where is allowed, list after a week.
May I please your lordship, I beg to mention for listing of concurrent.
Listing, please make a mention on Monday because this is not a regular bench.
Daily list item 1, motion BA.
8 minutes.
Yes.
My lord, in this case, my lord, the CD was called for and the CD is with item number 44 may be seen, my lord. This is BA and that is AD, my lord. My learned friend may. My lord, the petitioner was arrested on 28/2024, my lord. And the FIR, my lord, page number 8.
You are arrested on,
So this matter will be taken up along with 44 law.
My lord,
arrested on,
registered on, my lord, page number 1427. My lord, registered on 24/8/2020.
or arrested when?
20/08/2024.
28, 24.
Yes.
My lord.
Well, in this case, well, as he mentioned that item A, this is my lord tagged with item number 44.
So this
CD
matter may
receipt.
be
So, well, this matter may kindly taken up.
taken up along
We
with
have that record. Don't worry about it. We have the record.
My lord, since the CD is there, my lord, maybe disposal.
CD, she will have
CD is
CD
taken
has, but well, I have not gone through it. So, well, this matter may kindly taken up
after some time.
after some
Okay.
time.
along with 44.
44 we have. This is the record of 44.
Yes.
Don't worry.
After motion, my lord.
Nothing. CD is there.
Absolutely.
Item 2,
This is a lordship.
Yes.
483 application manner. And this is behind the part.
NDPS 21C.
Yes, ma'am.
Call for the case diary.
Yes, ma'am.
Sarsi proceeding.
Which,
Trial is proceeding, my lord.
Lordship's
5
matter
witnesses
has
were
been
examined.
succeeded.
pardon me?
5 witnesses were examined, my lord, out of 10.
Okay.
Matter has been
Then we,
succeeded.
when was the last bail application rejected?
Last bail application was rejected on my lord's page 69. I'm just
7.
Page number 69. 23 to 2024, my lord.
Huh?
23/02/2024.
Page 69. Lordship.
Page 69, my lord.
Where is the forwarding?
Forwarding report, lordship will find as page 23, my lord. It's 8/5/2022 dated.
Page
23, my lord.
23.
Date of forwarding is 08/05/2020.
Yes, sir.
Then it must go to the bench of Honorable Justice Chaudhary.
Yes, my lord. Poetry was granted bail on 30/11/23, which is at page 88, my lord.
Because The order by this bench is at page 70. The earlier order of 30/11/23 is at page 88.
Page 88.
Go ahead, go before the same bench.
Lordship.
Because then earlier, the previous order of that is 56 by this bench.
Yes, Lordship.
That is
Well,
14/11.
Yes,
After 14/11, 30/11.
yes.
30/11.
Perhaps this
This is
order
the
was not
latest one,
placed before
Lordship,
the
yes.
other bench.
Yes.
Okay, both sides are represented. This is noted that by order dated 14/11/2023. Passed by this 14. BA 3415 of 2023. Cleared for bail in BA 3415 of 2023 and BA 2999 of 2023 was rejected. By another order of coordinate bench dated 30/11/2023, co-accused was granted bail by order dated 30/11/2023. Passed in BA 3234 of 2023. This subsequently, the order dated 23/2/2024. This court had passed in BA 155 of 2024. The prayer for bail of the two petitions was rejected. It's true. And it is required that the bench which had earlier had the matter for a co-accused to take up the subsequent bail applications. It is deemed appropriate that the registrar raises this matter before the appropriate bench within bracket Honorable Mr. Justice Arvind Chaudhary. Bracket closed.
Well,
It come before same bench.
Yes, Lordship.
I'm deeply obliged.
Item 3,
You see, both sides are represented.
May it please the Lordship. My item 3 is a bail application of 483 matters, and connected item is 9 also is in this matter, item number 9. And they are matter connected with item number 14, where CD has already been called for matter by this honorable court. It is listed today, item 41.
Where is the FIR?
The fire Lordship
Item
will find at
41.
page 9 matter. It starts from page 9.
That is item 41.
41.
41 and 14.
Yeah, in my lord, item 3, 9 and
9 and
41 are
40
connected
may be
matters.
taken up
3,
together.
9 and 41. Okay.
That may be taken up together.
Together,
Lordship,
my lord.
after some time.
After some time. Okay. 3, 9 and 41.
Item 4,
Maybe, please, your lordship. Lordship, it is a 483 BNSS application, lordship. In relation to session case number 06 North Lucknow 2024 under section 417 376 of IPC, lordship. The petitioner was arrested on 16 to 24.
Where is the,
211 days till
where is the,
today,
where is the
lordship.
FIR?
Lordship at page
What
11.
trial is going on? Trial is going
Yes,
on.
lordship.
Yes, short-sighted matter, Lordship.
When was the charge sheet filed?
Lordship at
Charge filed on
nine.
'28 to '24, lordship.
Okay, let me call for the scan copy of the
Scan
case
copy of-
records. Let the scan copy of the relevant pages of the case records of sessions case number 60 within bracket NL bracket close oblique 2024 under section 417 oblique 376 IPC. A requisition from the Court of Additional Sessions Judge within bracket FTC bracket close Lakhimpur at North Lakhimpur. Next, the requisition may be sent by email with liberty to the learned trial court to send the scanned copy of the relevant pages of record through email for being placed before the court. Next, better list on. September 2024.
Item 5.
My pleasure, lordship. Lordship, 483 of BNSS, lordship, petitioner is 25 days behind the bar, lordship. FIR page number 13, 11%, lordship. Page 12, lordship.
Meenakshi vessel. 2 and 4 Meenakshi.
The petitioner is not named in the FIR, but lordship, OAQ says
Okay, you were arrested on
2007, 2020.
20,
2007, 20
20,
July.
20 July.
no, lordship, arrested on 19 August.
Arrested on?
Arrested on 19 August. At
Yes, yes, Lordship, I'm sorry, 1908. Lordship.
1908.
1908.
1908,
Yes,
lordship.
08.
Get the case diary.
City Lordship. Lordship is from Lakhimpur. Lordship, can it be a
23rd.
23rd?
Get the case diary produced on 23. Case diary was scanned copy thereof. They produced on 23/9/2024.
23 September.
23/9.
23. Last of like
6.
Item 6.
FIR is on page 10, madam. 44 days behind bar as on today, madam.
Next.
You'll have to have the case diary.
CD Lordship.
From which place?
It's from Barpeta Lordship, Sortebury PS.
Get it there next Friday, 20,
Lordship.
case diary on 20. Let the
right.
case diary be produced on 20/9/2024. Eight.
Eight.
This was go before Honorable Justice M.K. Kalita.
My lord, interim was granted. It was not absolutely not. In 4 cases, my lord, 5 of the co-accused have been granted interim, my lord.
No, but still it must go before the same bench now.
Yes.
Considering it was interim, my lord.
Both sides are represented. It appears that the connected matters, in the connected matters, orders were passed by the coordinate bench. So accordingly, the registry shall list the matter before the appropriate bench without bracket. Honorable Mr. Justice.
17, my lord, all the matters have been fixed. 17/9, all the matters have been fixed with CD.
On 17/9/2024.
My lord.
Item 10,
May I please, Your Lordship. My lord,
Connected matters.
application of
When is the connected matter listed?
connected.
AB 2438.
Connected matter.
No,
isn't it?
no, another
Perhaps there is
co-accused.
no connected matter, Lordship.
Yes, there is another co-accused asking for bail.
There is sole accused person, Lordship, in this FIR.
Call for the case diary and list the matter along with AB 2438. Should be case diary be produced. Let me check for me. And this AB 2438 of 2024, when it is listed next. AB 2438.
This is the present application 2438, Lordship. 2438, the present application, Lordship.
So this is the matter. Oh no.
There is only one accused person.
Only one accused person is there, Lordship.
What we actually is tracking of on cases against. Two cases are committed by the yeah, by which this is found in the I think this is okay, it is 10103.
Yes, Lordship.
You copy the case diary.
Lordship,
Let the case diary be produced on make it Monday, 19 sorry 19 No, not 19, 23, 9, 2024.
Lordship, along with the postmortem report possibly.
My lord, purity on suspicion, that is also stated in the FIR, lordship. I am paying
No,
for.
let us see what is the
City-
case diary because somebody has died.
Yes,
Somebody has died. Let us see why suspicion is on you.
Item 11.
So in this case, I am being led by Mr. A.M. Bora. He's on legs, so kindly.
Okay, after some time.
Item 14.
So this is for washing of a complaint, In the meantime, the complainant died. The other side, they filed 2 applications, one for imprisonment of the son as a complainant in the case, and the other is for vacation of the stay. Now, Lordship is kindly appreciate the application will
What is the, where is the complaint?
page 14,
Yes.
14.
14 of the petition.
Petition.
Yes.
You are for?
I am for the two accused persons.
You're for the accused.
Yes.
Okay.
The only thing,
After this, what has happened?
here the complainant died. So, they file an application, under Order 22, Rule 1, for substituting the
That was allowed.
not allowed. That is why it has come up. And in fact, there are the other cases, one is for
So
imprisonment of the.
here, what have you challenged here?
Here, the impute order, which your lordship will find at page 78.
78.
In fact, Lord,
355, 506.
page 78, 78, 79, and 80. This is the impute
I've
order.
seen that. Now the cases are only under 355, 506,
Yes,
34.
yes, Lord. In fact, what had happened in the
This order, you don't find any reason to quash this.
The only thing, Lord, there has to be, this is the complaint case, certain allegations were made, and in fact, Cognizance was taken under 294, 379, 420, and 34 initially,
No, but now it is only 355, 506.
But there has to be a case, Now the trial court came to a conclusion, that no case is made out under the sections under which the complaint was filed.
Correct.
Now the court takes out, and here the court, itself acts as a prosecutor. It makes out a different case.
When the court accepts the complaint,
Lordship.
it is examining the complaint, applying its mind,
Yes,
and then
exactly. But initially, after it was for evidence before charge. On the basis of that, at the time of framing of charge, the court made out a different case. In fact,
it's permissible. Even before judgment,
Lordship.
under 311, the court has power to do it.
No, but only thing is,
Alteration
here the problem is there has to be certain allegation. The allegations of the offense has to be attracted, The statements before Lordship, that was by the Justice Pathak's order, The proceeding was stayed because no allegation as such was made against the. No cases made out under these sections, All these statements are there. The only thing here, during the appendix of the case, the complainant died. So they filed 2 applications, One is for impeachment of the, in fact, substitution of the legal heir, the son of the complainant, and the other is for vacating of the stay,
Mr. Chetri, we can't allow your application
lord.
for substitution.
Now, my lord, if your lordship will permit me, my lord, with due respect, my lord. My lord, in CRPC, there is no straight jacket about this legal hair, my lord. Now, some judgment where it has got a ratio, my lord, where it says when a private complaint, when a main complainant dies, and the legal hair is to be made.
Show us that.
My lord, that judgment contains, my lord, JK in the new my lord, BNSS, my
No,
lord.
don't go by that.
Yes, my lord, there is one judgment I have brought for your lordship, my lord. I do judgment with details. So, my lord, after that, the one legal hair is come, my lord, then it goes to the trial court, my lord, under 302. And the new BNS is the 339, permission to conduct the prosecution. This is the fact, it remains here, my lord.
Okay.
Balasep Thakkar case is also there, 2006, my lord, 5 SCC also.
Which one?
Balasep Thakkar case, ma'am. 2006, 5 SCC, 530, my lord.
Yes.
Oh, sir.
Yes.
So, well, regarding substantive, my lord, I do not have any objection, my lord. But the fact remains only thing, my lord. These allegations are personal to the complainant. my lord.
That is
Yeah.
why.
Now, 355, even my lord, if your lordship goes by the statement of the witnesses, no case is made out, firstly. Now, lordship, only thing, if your lordship is will hear the matter, my lord, I have no objection. But the fact remains, unless and until the person is substituted, my lord.
We are hearing it will pass orders together.
No, so far, my lord, because if the miscase for vacating the stay, my lord, that is, my lord, premature. Because unless and until this person is, my lord, the person, the son is substituted, my lord. As on date, my lord,
Will pass orders together.
That is why.
lordship.
That is why substitution is necessary. My lord.
Let him complete.
Yes, he is not completing, my lord.
Yes.
No, whatever is on, my lord, that lordship is no doubt, my lord, will be passing. But at the same time, insofar as the complainant, the present applicant is concerned, my lord, he has no locus as of now, my lord, in filing the application under for vacating the stay. That point is there. My lord, unless he is impeached first, then, my lord, this has to be considered. And lordship is the only thing, my lord, if your lordship is instead of, my lord, disposing of the miscase, my lord, lordship may hear the matter, entire matter, my lord.
We are hearing you.
Lordship. In that case, my lord, lordship will kindly come to the complainant. May I just at page 14, my lord.
Just a moment. Where is the complaint?
Page 14, my lord. So what is the basic allegation, my lord? And lordship will kindly see the offense under which The alleged allegations were made, Milord. Nothing, Milord, but laying of a pipeline, Milord, by the authorities concerned. Milord, the allegation was under section 294, 420, 317, and 34. Milord, the authorities said, Milord, while laying the pipeline, Milord, 1 meter of pipeline came inside my area, Milord. I'll just take page 15, Milord. The complainant submitted that written complaint against the accused number C. Jagat Kaur on 26/5/2017, stating that C. Jagat Kaur has illegally taken water supply connection from Narcotics water supply project. That the authority, after receiving the complaint and taken necessary action against C. Jagat Kaur and removal the illegal connection of water in the residence of Jagat Kaur. Now, this, Milord, will kindly take note, Milord. There was no water connection. It was just, Milord, the pipes were being laid at that point of time by the authorities, Milord. It is not that, Milord, we laid down the pipes. The complaint said the accused person illegally convened a general meeting, was sitting on 11/6/2017 in the Norakapur Namgor premises, and at the time of meeting, the accused person physically attracted the complainant and also threatened him not to disturb them in the earlier course of time of this project. That the complainant, accused person practically danger in nature, and they formed a illegal committee in Norakapur PSO and so through a general meeting, including in spite of SC member, which is mandatory in this project. The complainant says the commission of illegally connecting water supply are evidence from the report of the PHE authority. When they are after verification found the illegal activities of the accused, disconnected the connection as per number so and so, or 26/7/2017, issued by the assistant executive engineer. In this connection, a photoset copy of the said letter, copy of which was engrossed to the complainant's advocate in the light of the notice dated 16/6/2017, is annexed here to and marked jointly as Annexure 1. That the complainant further said that the behest of the accused, the committee was formed.
Just take us to the initial deposition. Where is that?
No, Lordship. Before that, Milord, I'll just take you to, Milord. I'll just take to page 18, Milord.
18.
Page 18, Milord.
What is that?
Milord, this is the letter which was made referred to, Milord.
Forget that.
Because, Milord,
initial deposition.
the allegation was, Milord, that I had 217 was there, Milord. Lordship will kindly, that is why, Milord. This connection was by the PHE, Milord. They, Milord,
Yes, okay, we have seen that. Just come to that initial deposition.
Page 23, Milord. This is statement under 200, Milord. The SMS version is also there, Milord. Just may I read, Milord?
Okay, that's all.
Yes, Milord.
Page 23, 24, initial deposition.
Initial page 23, Milord.
Yes, 23, 24.
23, 24, and in fact, 25, 26 is the written version, Milord, and 28, Milord, under 202. Then, Milord, page 32. Now, Milord, Cognizance, whatever Lordship will find at page 36. Order
Page
dated,
number?
Cognizance page 36, Milord, order dated 26/3/2018. So, on the basis of the statements, Milord, the court found a prima facie case under 294, 379, 420, 34. In spite of the fact, Milord, that there was no water connection, Milord, it was just laying down of pipes at that point of time. And in fact, Milo, the extended portion was cut off by the PHA authorities.
It's okay, 294, 379.
294, 379, 420, 34.
79 theft.
294 Milo obscene language, Milo 317 is theft, 420 cheating, 34 common intention.
420 is cheating.
Now, why was Miller I rely on page 18 Miller? What is the reason, Miller? Here, the authorities themselves say that I have nothing to do. They were laying down the pipes. When it was found that a certain portion was onto my land, Miller, they did cut off the extended portion. That is what at page, Lordship will kindly come to page 18. And in spite of where the queries of cheating.
No, that's okay. It's not relevant for because of the
No,
fact that
well, this was a part of the complaint.
This is a person who is not examined by the court. The author of this letter is not examined.
But that was relied upon by the complainant, Miller.
That is one part. That is one part.
Lordship.
But to this, there is nothing on record in the initial deposition. There is nothing on record to show that this person who is the author of this letter was examined.
No, but reference was made in the complaint itself, Miller.
Where is the statement of the complainant on this?
In the complaint itself, they have stated, Miller. And in fact,
initial deposition, you see, complaint may say so many things.
No, Miller, Lordship will see page 23 then.
23.
Last 3 lines.
Yes.
In fact, last 4 lines. The engineer asked me to submit an application, so I have submitted. After 3-4 days, the engineer has come and removed the stolen pipe connection.
Correct.
But
this doesn't refer to the complaint. This letter is never referred to. You know the principle in the initial deposition.
No, sir.
You must indicate the document on which the complaint is based.
No, sir.
Is it not?
No, sir.
Now, can you think of a complaint where you don't refer to any document, and for the if for the purpose of cognizance, a document is not considered by the court?
No, sir.
Can this court in quashing read that document and then make its evaluation as if it's an original court?
Well, that is what, Milord. Now, Lordship, first and foremost, Milord, where is the mere allegation? Lordship, because it was a case of, initially it was a case of theft.
So there's no necessity of reading something which the court has not relied upon.
No, Milord. I'm not saying that. Milord, for the purpose of taking cognizance, the court has to come to a primary facie finding, Milord.
The court does not say that the privacy opinion was drawn on the basis of this.
No, I'm not saying that. Milord, but certain sections have to be attracted, Milord. Where is the question of cheating?
No, we're taking your point.
Lordship.
That is what I'm arguing.
No,
because taking your point, if this is not taken, then it's a document on which the cognizance is not based. You see, let us say for a complaint, let us say what is a complaint? For example, labor commissioner comes, or the department comes, finds that a person is working, is operating a shop without a labor license. In the complaint, he will have to say that there is a requirement of having a complaint, and therefore in the office it is not there. Or if the ECA, for example, this EPF, they find that a person X is working in a shop who's not accounted for, then he takes the statement of that labor, and then that is produced before the court as an evidence that when we went to that shop, this labor was found without any entry, and therefore he is escaping EPF. So then only the cognizance is taken in that manner. See, if a document is there and cognizance is not taken, it goes to your benefit.
True, Milord. Here, Milord, the only thing is, their basic allegation was, Milord, it was cheating, theft in the complaint, Milord. That was the case. Now, going by the initial deposition, Milord, Lordship will see whether these 2 sections are firstly attracted.
We have seen that. Now we hear Mr. Chetri.
Now, Lordship, thereafter, my lord, I'll take you to, my lord, I'll just take you to page 77, my lord.
What is that?
No, this was, in fact, the evidence before charge was also there. My lord, Lordship kindly come to page 71. Initially, Cognizance was taken under those sections, my lord. Subsequently, my lord, during evidence before charge, Lordship will kindly come to page 71. The
Yes.
statement of the complainant. I am the complainant in this case. I have filed this case against the accused person, Sri Jagat Kumar and others. I am the president of so and so. The government was making arrangements for connection of water supply pipe in our area. But
Yes.
now the government was making arrangements for connection of water supply pipe in our area, and I had received an order to collect 220 from each family as security. I collected money from some households by giving receipt, but Sri Jagat Kumar refused to give money. On day, an engineer of PHE department came to the house of Jagat Kumar and found that there was an illegal pipe connection in his house. So he asked me to come to his office and file an application. On the basis of an application, the engineer came to the house of Jagat Kumar and removed the pipeline. That the accused person illegally convened a general meeting which was sitting on 11/6/2017 in the Norokapur Namgor premises, and at the time of the meeting, the accused person physically attacked me and also threatened me not to disturb them. In the earlier course of time of this project, that the accused person practically dangerous in nature, and they formed an illegal committee Norokapur PSS so and so through a general member, included in spite of SC member, which is mandatory in the project, that the commission of the illegally connecting water pipe are evident from the report of the PHA authority, where after verification found the illegal activities, and the accused disconnected the connection as per the so and so dated 26/7/2017. This is the letter which was referred to, my lord. Issued by the assistant executive engineer. In this connection, a photostat copy of the said letter, of which was endorsed my advocate in the light of the notice dated 16/6/2017, is annexed here to and marked as jointly as Annexure 1. So my lord, that has been taken into consideration.
Now, yes.
At the behest of the accused person, the committee was formed to fulfill its event design. In the formation of the committee, there under the circumstance, it is crystal clear that the accused has committed offense as mentioned above.
Yes.
Now, Lordship will next page again, his statement was again recorded, but that was discarded. Here, he again made contradictory statements. The same person, there is an order, judicial order, that the subsequent order will not be, the statement will not be taken into account. I'll just take you to the statement, Milord. I'll just take you on this on 17/5/2017. That is your lordship is page 73.
Just a moment. This is a deposition, page 71. Is a deposition
Of
after
right-
charge.
Before charge.
Before charge.
This person's, the complainant statement was recorded twice. In the second statement, Milord, he made contradictory statements. Although it was discarded, Milord, by a judicial order.
Yes.
Lordship, I'll just take you to page 73 now, Milord. I have filed this case against Jagat Kumar Logan so and so. On 27/5/2017, the accused persons came to my house at around 9:30. They called me out for a walk. All of us sat on a bench outside my house. They threatened me to withdraw the case, which I have filed against them for illegally taking water supply connection. They asked me to come to the Namgor for a meeting in the next morning. I visited the Namgor with so and so. When we reached the Namgor, the accused person told the persons accompanying me that they had no right to enter the Namgor and that they are going to be a cabinet meeting. The accused person continued to abuse me. My son Bhupen Boro, who had arrived for the meeting, was also abused by the accused person. The accused person also made gestures as if they were going to catch us and assault us. Seeing their aggressive posture, my son advised me to return back to our house. So this is the statement, but this was discarded. Lordship will see The statement, the difference in the statement be at page 71 and 73. My lord. Now, Lordship will kindly come to page 75. Is the son, my lord, who is the applicant before Lordship as on today? My lord.
Yes.
Complainant is my father. He has filed this case against accused Jagat Kaur so and so. In the year 2015-16, a TSP water scheme was launched and the work was complete in the year 2017. At that time, the accused Jagat Kaur, who is our co-villager, had stolen 1 meter of pipe laid out in the supply water. So, Lordship, again, the case of stealing comes in. My father had made a written complaint before the engineer overseeing the project. On 3/6/2017, the engineer came to the spot and took measurement of the pipe, and the engineer severed the extra pipe that was stolen by the accused Jagat Kumar. On the same night, all the accused persons visited our house and threatened my father and abused him verbally and asked him to withdraw his complaint. They also asked him to visit the Namgar on the next day, which was a Sunday. My father visited the Namgar on this next day along with 3 to 4 other persons. The accused person drove away the people accompanying my father, and they attempted to assault my father. At that time, I reached the Namgar. So, my lord, he was not even there. He reached after the incident. What transpires from the statement, my lord. And it was an attempt, my lord. Now, Lordship will kindly come to page 77, who is an independent witness, my lord. These are witnesses of the complainant. It's not my witness, my lord. I know the complainant at page 77.
Yes.
I know the complainant. He has filed this case against accused Jagat Kaur so and so. I know all the accused persons. All of them are my co-villagers. In the month of June 2017, there was a meeting held at our local Namgar. I was present at the meeting. In that meeting, there was an altercation between both the parties. The accused persons restrained the complainant and his son, Upen Boro. In fact, my lord, it transpires that I prevented. Now, Lordship will see. So, now, for a minute, my lord, Lordship will kindly come to page 18, my lord, because reference has been made, my lord. I'll just take you to their case initially rests, my lord, on the basis that I had stolen the water supply connection. I had dragged the water supply connection to my place, my lord. Lordship is taking page 18, my lord. With reference to the subject cited above, I am to inform that works of construction of Narcotics PSS are almost complete. After laying the distribution line, trial line for a scheme is going on and no any house connection is provided till date. The formation of the users committee is under process. The house connection to the beneficiaries will be provided by the users committee after observing all necessary formalities as per government guidelines. So connection was not even there, my lord. Regarding illegal connection to the premises of Jagat Kumar, as reported by the concerned site in charge, I would like to inform that about 1 mm of 50 mm dia GI pipe entered into the premises of the Jagat Kumar. This is due to laying of 6 meter of 50 mm dia at the end, dead end of the distribution system. After receiving the complaint, the undersigned visited the site on 3/6/2017, and after proper verification, the excess 1 meter was duly disconnected. The photocopy of the necessary layout drawing of the distribution pipeline and photograph of disconnection is enclosed here. Lordship, the layout is at page 19. The photograph is page 20. Now, Lordship will see because there is a bend. The pipe is of a particular length below. So while laying down, Lordship will this is marked as plot of Jagat Kumar. So, Milo, the initial case was of cheating, firstly, of and theft, Milo.
Yes, Mr. Chetty.
My lord.
In fact, if your lordship, the impugn order, my lord.
May I say that? Let him.
May I please your lordship, my lord, with all respect, my lord. Now, my lord, what my learned friend has spoken, my lord. He has spoken about the complainant, my lord. The complainant is not before your lordship, my lord, he died. Now, what the court will do at this stage, my lord, when the complainant dies, whether the legal heir has right to sue or allow for prosecution further. That is one point. Second point is that at this stage, when
You're fundamentally incorrect. Choice of words are wrong. If you say right to sue, and in criminal side, it is right to prosecute.
Prosecute, yes, my lord. I'm sorry, my lord. Right to prosecute, my lord. Further, my lord.
No,
So at this only that must to be decided, my lord. Only that point. When complainant died, at the stage of filing my affidavit in opposition before this court, he died. Now this court has to see only the thing is whether the legal heir can prosecute in the trial court or not. That is the legal point to be decided by this court at this stage. And nothing further, my lord. Because already the complainant died. Now,
You
second
want to-
part is that the prosecution by the son, legal heir.
Corollary
lord.
question. You want to submit anything on merit or no?
My lord, at this stage, my lord, if your lordship will see there.
No, yes or no? There's
No, my lord. No, my lord, because the
That's-
complainant dies.
That's okay.
So
Then
second,
we
all
heard
the
you-
parts will come with the son, my
Then-
lord, to proceed, my
then
lord.
we have heard you will pass orders. We get the order on Monday.
My lord,
Today I will not be able to have told.
my lord. Only, my lord, your lordship consider the Balasab Supra case and the
Definitely.
Chand Devi Daga case, my lord.
Definitely.
And 302, my lord, the original when complaint dies. So, my lord, I've given the.
Any experience that in this bench, you have cited any case when it's not been considered?
With all respect, my lord. With all respect, my lord.
No, with all respect means yes or no.
With
Respect, we understand.
yes, my lord. We can only submit before lordship, my lord. Once we submit our citation of the apex
No,
court,
since
my
you-
lord. That is the
since-
law, my lord. That is
since-
the order, my lord.
Since you stressed that you please consider it, that's why I'm asking.
My lord.
Is there any experience in this bench?
No, my lord. No, no. With all,
Any
no, my lord.
citation given is not
Of
considered?
course not, my lord. Of course not.
Then take care of
Not only this bench, my lord. Any of the bench of the court,
No,
my
no, no,
lord.
I'm concerned about me only. I'm
Obliged.
Much obliged.
Malik, Mr. KD Chetri, yes, are they for petition? 1 minute. We'll take a break and.
Much obliged.
Wait, please, your lordship.
Report has come.
My lord, report more not received, my lord.
Then ask for this IO to be present. This is the last order. Both sides are represented. Mr. R.J. Burwal and APP. By referring to order dated 3/9/2024, Mr. R.J. Burwal and APP was asked as to whether the IO has sent the report of the connected of Manipur PS case number 108 of 2023 in terms of orders dated 27/4/2024, 14/8/2024, and 3/9/2024. To the said query, the learned APPA submit that the report is not received. Next paragraph. Accordingly, the court is inclined to take note of the order dated 3/9/2024, wherein it has been mentioned that in the event the relevant report is not received in terms of the previous orders, the IO shall have to remain personally present before this court. Next paragraph. Accordingly, the superintendent of police Bongaigaon shall ensure that the IO of Manipur PS case number 108 of 2023 shall remain present in court on 23/9/2024 at 10:30 a.m. and he shall not leave the court till the matter is taken up. Full stop. As the IO of Manipur PS case number 108 of 2023 has obeyed 3 orders referred above, passed by this court, his absence in duty shall be he shall be marked absent on the time during the period of his travel and appearance before this court. Next paragraph. On appearance, the IO shall explain to the court his conduct of willful disobedience of the order of the court. Full stop. The IO shall also address the court as to why suo motu contempt should not be initiated against him for his failure to obey the orders of the court. Full stop. The IO is at liberty to take such legal assistance as he may so desire. For his appearance, the court on 23/9/2024. Next paragraph. The learned APP shall send the copy of the order, downloaded copy of the order to the Superintendent of Police, Bongaigaon, as well as to the officer in charge of Manipur Police Station to ensure compliance. Next for list on 23/9/2024.
Item 16.
Lot space fixed on 23/9, man.
23/9. Today is
13, man.
13. Give it 10 days time.
A copy of the order by furnished.
We said downloaded order.
Morning.
If you want, you tell the court marshal, he'll give it to you. No issue with that. Yes, item 16. Yes.
Let's see.
Yes.
This is a petition for passing of a criminal proceeding against the petitioner.
Yes.
In this, respondent has filed a criminal complaint case under section 139 of
Act, wherein I am respondent, I am the accused number 4. The complaint petition is page 25.
25.
Yes.
Yes.
Yes. I am accused number 4 in this case.
Yes.
Times Square Alloys Limited is the company. I was one of the director of that company.
Yes.
I filed this petition for quashing on a limited ground that the complainant has not followed the mandatory condition imposed in section 141 of the Negotiable Instrument Act.
What is that?
Negotiable Instrument Act, section 141.
What is that? What is that?
Yes. For a vicarious liability, there must be two conditions. That the director must be in charge of and was responsible to the company for the conduct of the business of the company.
The complaint was filed on which date?
Complaint was
Complaint petitions were initiated when?
2013.
2013.
13.
But then you don't have a case. Somewhere in the documents we have mentioned that in 2016 you had resigned from the board of directors. So in 2013 you were very much in management. You're a director.
No, I was in the management. By my case is that for vicarious liability, they have to follow the mandatory provision of section 141. May I read?
Yes.
Section 141 of the Negotiable Instrument Act.
Negotiable Instrument Act. Just read that slowly. Read that.
If the person committing an offense under section 130 a company, every person who at the time of offense was committed was in charge of and was responsible to the company for the conduct of the business of the company, as well as the company, shall be deemed to be guilty of the offense and shall be liable to be proceeded against and punished accordingly. There are two conditions which has to be followed by the complainant. Now I am reading para 2 of the complaint petition, which is at page 27.
27.
Mary?
Yes.
In para 2 of the complaint petition, that the accused number 1 and 2 is a public limited company. The accused number 3 is the chairman, who is the signatory of the check. That the accused number 4 is the director. I am the director. I am accused number 4. Accused number 5 is responsible person for day-to-day business. Accused number 5 is Rajat Sarawgi. And the accused number 6 is the chartered accountant of accused number 1 and 2. 6 is the chartered accountant. As such, all the accused persons are related to the day-to-day business of the company, and they are responsible jointly and severally for the acts of the accused company. So there is no averment against me in the complaint petition. Only one line is there that accused number 4 is the director.
Yes.
And in the last paragraph, last part of this paragraph, they assume that as such, as I am the director of the company, so I am liable.
Yes, and what do you say about the rules of interpretation? You see, para 2,
Yes.
that the accused number 1 and 2 is the public limited company, comma. The accused number 3 is the chairman, comma. Accused number 4 is the director, comma. Accused number 5 is responsible for the day-to-day business of the accused number. Of the accused number 6 is the charter accountant, and the accused number 6 is the charter accountant will come. Accused number 1 into n as such. All the accused persons are related. So I am referring to these commas.
Yes.
So when there is a comma, how do you read this director? Sorry, accused number 5 separately.
Because they are presuming that as we are in a position of director, they are using the word
you are
as
not the director. He doesn't say you are a director.
he said accused number 4 is the director. In the second line, accused number 4 is the director.
5. You said you are for 5. No, you are for 4.
I'm 4.
Oh, acha. You are the director. Yes.
I'm the director.
Yes.
And he presumed that as I am the director of the company, I am liable because he used the word as such. As such, all the directors are related to the day-to-day business of the company. But the act says it should be specific.
You have a copy of your audited balance sheet for the financial accounting year 2000. This is 16, right? The
No,
2016 financial document. Do you have a copy of your audited balance sheet?
No, sir.
Are you aware why I'm asking that?
Yes.
Are you aware why I'm asking that?
Yes, that I don't have. That I don't have.
No, you don't have it. But are you aware why I'm asking that? No idea. You see, because as per the requirement of the accounting principles, what is called? Accounting Code 17 or Accounting Principle 17, which is now in force. And in 2016, I think Accounting Principle 10 or 12 was in force. I forgot. I'm a bit out of touch of books, so I forgot. That is the accounting code which was followed in a company. That requires even then in 2016 and even now in 2024, the requirement of law is that each and every balance sheet must be signed by every director. So once you sign as a director, you can't say that I am not taking part, I am not participating in the business of the company or management of the company.
My submission is participating in the management of the company and participating in the day-to-day business of the company is two different things.
No.
Because I may take part in the management of the company.
No, day-to-day business. Many people don't take interest in day-to-day business. No.
Because
I know of a person here. I'm just giving a small example. I know of a person here who does not attend his business but knows everything. Even my deceased father, he was not a lawyer. He never came to court. But he would have interest when I go back home. He would have interest in asking me that what did I did in the entire day, and he was probably in knowledge of the business of what I was doing. He left this habit when I came here in this bench. Till the day I was there, he always treated me like I was a very small kid and then asked me everything, what I did from day to night. And I had to report to him. He would take an offense if I did not report. He was not a lawyer. He was not my senior. But he took a report everything which happened in the day. So you see, that is not your case. As a director, even if you don't participate, you are deemed to be aware what is happening in your company. Is a private limited company, right?
It's a private limited company.
And all these people, 2, 3, 4, they are related. Are they? They are in blood relation.
4 is my father. 3 is my father.
She is your father.
Yes. And 5 is 6 is the
So
chartered accountant.
my example fits in. My
Your
example
Honor is
about my
right,
own
but-
home, it fits in. As a father, when they are there, he's taking part in the management. You are silently managing it.
Well, I'm not on that part. Managing a company is different thing. But managing, taking part in the day-to-day affairs of the company is different thing. There are two things. Some things there. Because it's a criminal liability. If a company does a wrong, its directors or whoever taking part in the day-to-day business of the company are liable. Not only directors. The act is very clear. Every person who at the time of offense was committed.
Okay. Just tell me, in the bank, have you given any power attorney that you are not a signatory, authorized signatory, and you don't participate in the banking business? In the bank account of the company, when you were a director, did you give any letter that you are not participating in any affairs? Number one.
The check itself says I'm not the signatory.
No, not a signatory is a different thing. I wanted to know, because you see, you are an industry.
Yeah.
I just wanted to know that whether you have informed the bank that you are not participating in the day-to-day affairs.
That I have stated in my complaint, in my petition here, because in 2010, I came to Guwahati and actively taking part in another company. And I am not, that document is not with me, whether I have given a letter or not. But here, every person who at the time of offense was committed was in charge of and was responsible to the company for the conduct of a business of the company. So my humble submission is that he must be in charge of and he must be responsible to the company for the conduct of the business of the company. For making any person, here the word used is every person. So anyone can be liable, vicariously liable. Both the conditions must be fulfilled and they have to ever in their complaint petition regarding this, regarding both the condition, because the word used is and. In charge of and. So it should be read as conjunctively because the word is used and. There are two conditions. And they have to ever in their complaint petition, which is lacking in their complaint petition. So the primary condition they fail to ever in the complaint petition.
Okay.
So regarding this, I have to submit one citation. May I?
Please. Yes, please.
I have submitted a copy. SMS Pharmaceuticals versus Nita Bhalla. I'm reading para 4. In the present case, we are concerned with criminal liability on account of dishonor of check.
Just a moment. Sunita Bhalla. This was suggestion was given last time.
Last time.
Sunita Bhalla, I'm not finding. There's a list. SMS Pharmaceuticals.
2005,
Silly Thomas. Municipal Corporation Delhi. Menaben. Ketan Bhai Shah. These are the only suggestions we have here. Can you give a copy?
I have submitted a copy.
It's not here. We told
There was a bunch of.
These are the copies. There is at least 4 cases. Sunita Bhalla is not here. Nita Bhalla.
Nita Bhalla is SMS Pharmaceuticals.
SMS, that is there. That is there. Yes. Yes.
This matter arises from a reference made by a 2-judge bench of the Honorable Court for determining the following question to a larger bench. I'm reading the point number, whether a director of a company would be deemed to be in charge of and responsible to the company for the conduct of the business of company and therefore deemed to be guilty of the offense of the company. This is the question. Case 5, para number 4. May I read?
Yes.
In the present case, we are concerned with the criminal liability on account of dishonour check. It primarily falls on the drawer company and is extended to the officer of the company. The normal rule in the cases involving criminal liability is against vicarious liability. That is, no one is to be held criminal liable for the act of another. This normal rule is, however, subject to exception on account of specific provision being made in a statute extending liability to others. Section 141 of the Act is an instance of specific provision, which in case an offence under Section 138 is committed by a company, extends criminal liability for dishonour of check to the officer of the company. Section 141 contains conditions which have to be satisfied before the liability can be extended to officer of a company. Since the provision creates criminal liability, the conditions have to be strictly complied.
Yes.
The conditions are intended to ensure that a person who is sought to be made vicariously liable for an offence of which the principal accused is the company had a role to play in relation to the incriminating act, and further that such a person should know what is attributed to him to make him liable.
Yes.
So he has to explain how in what manner I am liable, which is lacking in his complaint petition. Para 18. Last.
Yes.
To sum up, there is almost fifth line, a clear case should be spelled out in the complaint against the person sought to be made liable. Section 141 of the Act contains the requirement for making a person liable under the said Act. The respondent falls within the parameter of Section 141 has to be spelled out. A complaint has to be examined by the magistrate in the first instance on the basis of averment content therein. If the magistrate is satisfied that there are averments which bring the case under Section 141, he would issue the.
Let me cut it short.
Sir.
You see, you are relying on a citation which refers to a Companies Act 1956.
Yes.
Correct. This is an offence of which year?
2013.
2013. What is the date?
It is 10/2/2013.
The date of check?
10/2/2013. Page number 47.
10/2/2013.
2013.
10/2/2013.
Yes.
The Companies Act 1956. This is like a layer. Just a moment. Just a moment. My whole book is no longer there. Just a moment. Yes. I'm getting the whole book. I'm just not having that old book, but in the new act and in the old act, there is a provision in the new act you'll find 184 is disclosure of interest of the director. Now, for that, the director will have to disclose that he has an interest in certain matters. Therefore, when resolutions of a company is taken, as an interested director, he may not vote. That is the idea behind. So if you have circulated in yours is you are citing a case which is a public limited company. Yes. Correct. And yours is a private limited company. So in a private limited company, has you made a disclosure to the directors that you don't have any interest on those matters which relate to any financial transactions or accounts? And therefore you exclude yourself from the day-to-day management. Otherwise, in a private limited company, for a director to come and say that I don't know about the affairs, the checks are issued without my knowledge.
Yes, in 2012, I have issued a letter to the management that as I am in Guwahati.
No. Letter, you see, letter doesn't, in a company, letters don't matter because these letters are privately circulated documents.
Yes.
You don't have any documentation of when you actually issued it, when you gave it, whether it is a backdate receipt, whether it is not. Because the notification to the company of your disclosure of your interest would be taken into account in the board of directors resolutions. Those resolutions are filed before the ROC. So if you can show us some connectivity with regard to the empowerment of the director, then we are glad to accept it. In a private limited company, the principle of private limited company and public limited company are different. There may be in a public limited company a director who are disconnected in the affairs of the company. In the new act also, there's a requirement that there should be public participation and therefore there are directors who are nominated. He may not be involved in the day-to-day affairs. So that is the distinction. In a private limited company, you don't have a director who is an uninterested director. So that principle, if you're wanting to invoke, I have my own personal reservations.
But in this case, for vicarious liability in a company.
No, you see, you must show that you don't have. Is 106.
No, sir.
106.
Here the case is different. Here
No,
the
no.
case is different
The
because
principle 106 of the Evidence Act
Yeah.
is very clear that this is something which you know, it's a closed door organization. You
No.
must tell us what is happening inside your room.
that comes later on. If
No.
they complied with the condition, then the duty ownership to me. This is
If
because
it's a
this
plain
section,
case, one statement is enough that they are involved in the management.
no, sir.
How
Because
does one prove it?
here the liability is criminal liability. And that's why section 141 clearly says that he has to comply to two conditions. The word used is and. So both the conditions must be read conjunctively. Because he must avert that I am in charge of and was responsible to the company for the conduct of business of the company. Both the conditions, his primary responsibility is his. If he complied with the condition, then the ownership to me. But here, he failed to explain this because this is a criminal liability. Section 141 clearly says that being a director, I am not responsible. May I read para 19 of this judgment?
Please.
19B. Merely being a director of a company is not sufficient to make the person liable under section 141 of
This is
the
a
Act.
public limited company. Supreme Court is dealing with an issue which is a public limited company.
But here the word used is company. Section 141 of the
We all know under the Companies Act, what is a private limited company, what is a public limited company.
but the act says that he must comply with the condition. Primarily, he has to comply with the condition. Here there are two conditions he has to follow. But from the reading of the complaint petition, it can be inferred that he has not complied with both the conditions.
Okay. Yes.
So, Mary, a director in a company cannot be deemed to be in charge of and responsible to the company for the conduct of the business. The requirement of section 141 is that the person ought to be made liable should be in charge of and responsible for the conduct of the business of the company at the relevant time. This has to be averred as a fact, as there is no deemed liability of a director in such cases. Here, as I am a director of the company, he presumes that I am liable.
Yes.
So may I refer another judgment, C.B. Thomas, which I have given. Versus Somani Ceramics Limited.
Yes.
Merit? Para 12. It is not averred anywhere in the complaint that the appellant was in charge of the conduct of the business of the company at the relevant time when the offense was committed. What is stated in the complaint is only that the accused number 2 to 6 being the partners are responsible for the day-to-day conduct and business of the company. It is also relevant to note that an overall reading of the complaint would not disclose any clear and specific role of the appellant. My case is squarely like this. In the statute noted dated so and so, next para 15, page number 18. Page number 18, second line.
Just a moment.
May
Just a moment. Yes.
Page 18, second.
Yes.
Merely because somebody is managing the affairs of the company, per se he does not become in charge of the conduct of the business of the company or the person responsible for the company for the conduct of the business of the company. For example, in a given case, a manager of a company may be managing the business of the company. Only on the ground that he is managing the business of the company, he cannot be roped in based on the subsection 1 of section 141 of an act. Last line. Only by saying that a person was in charge of a company at the time when the offense was committed is not sufficient to attract section 141(1). Para 16. Merely become somebody is managing the affairs of the company, per se, he would not become in charge of the conduct of the business of the company or the person responsible to the company for the conduct of the business of company. A bare perusal of section 141(1) would reveal that person who at the time the offense was committed was in charge and was responsible to the company for the conduct of business, as well as the company alone shall be deemed to be guilty. Only that person.
Yes.
So since the abutment and the complaint are insufficient to attract section 141 of the NI Act, and in page 20, regarding the word and it was cleared, sir. On a plain reading, it is apparent that the word was in charge of and was responsible to the company for the conduct of the business of the company cannot be read disjunctively, and thus the same ought to be read conjunctively in view of the use of the word and in between. So both the conditions are mandatory.
Yes.
Yes. There another judgment, Dayal D'Souza versus Government of India. 2021.
No. We have only 4 cases. SMS Pharmaceuticals, Sidney Thomas, Municipal Corporation of Delhi, and Manaben Ketan Bhai Shah.
Manaban Ketan.
These are the 4 judgments here given in this list.
There is a Municipal Corporation of Delhi, is there? Municipal Corporation of Delhi versus.
Yes, that is there.
Malab?
That is there. That is available.
The same judgment is quoted here also.
Okay.
In para 14. May I?
Yes.
Reliance has been placed on the word as such in order to argue that because the complainant does not attribute any criminal responsibility to accused number 4 to 7, except that they were in charge of and responsible for the conduct of the business of the company. It is true that there is no clear abatement of the fact that directors were really in charge of the manufacture and responsible for the conduct of the business. But the word as such indicates that the complainant has merely presumed that the directors of the company must be guilty because they are holding a particular office. Paragraph 15. So far as the manager is concerned, we are satisfied that from the very nature of his duties, it can be safely inferred that he would undoubtedly be vicariously liable for the offense. Vicarious liability being an incident of an offense under the Act. So far as the directors are concerned, there is not even a whisper, nor shred of evidence, nor anything to show, apart from the presumption drawn by the complainant that there is any act committed by the directors from which a reasonable inference can be drawn that they could also be vicariously liable. In this circumstances, therefore, we find ourselves in complete argument with the argument of the High Court that no case against the director has been made out, especially on the allegation made in the complaint and the proceeding against them were rightly caused. They have used the word as such in the complaint petition. In paragraph 2 of complaint petition, page number 27.
Yes.
So such presumptive accusation against the directors without any specific abatement in the complaint petition is not sufficient. Because in the paragraph 2 of their complaint petition, the line is as such, As such, all the accused persons are related to the day-to-day business of the company and they are responsible jointly. This is a presumptive accusation.
Yes. Continue to.
Lordship. Lordship, I seek your indulgence. Item number 11, which it passes over timing. So it was, senior counsel had to leave for some work. Can it be adjourned for today? I have taken the consent.
I beg to appear, but I have filed an application for vacating the stay. I'm requesting for some short date subject.
We'll take it up on Monday then. We'll take it up on Monday.
Monday, Lordship, I'll just have to inquire if he's, because he has.
Because if we see, if he's filing an application for vacating, we have to take it.
No, that has been considered. In fact, the case
That is
has come,
pending
there has been
since April.
considered, it said that it will come up for final hearing.
We don't know about that. He's saying that his application is there.
Yeah, it was there, and on 23/5/2023, it was clearly written that it will come up for final hearing. So all the things were considered. So that, in that view of the matter.
So that I got. Item number?
Item number 11. Lordship takes up the order dated 25/5/23.
Your application is
IA
312.
312.
No, 312 is to be taken up.
It was filed in April 2023.
11/6/2024, there is an order. After hearing counsel for parties, list the matter for hearing in connection with IA criminal on 28/6/2024. We can't help it. Monday. What's the representative? The prayer made by Mr. R.J. Das, counsel for the petitioner. So, for the petitioner. No, you said the Mr. R.J. Das, counsel for the petitioner, pays for adjournment. For Mr.
A Phukan, your lordship,
A
for
Phukan,
respond number 2.
Learned counsel for respond number 2. It submitted that his interlocutory application for vacating his stay is pending. Accordingly. Not a on the prayer made by counsel for the petition, the matter stands adjourned today. Next paragraph. As this interlocutory application is pending since 2023, list on Monday, 16/9/2023.
Interim order maybe can.
Interim order passed today, stands extended till.
Permit me to address the honorable court through VC if it's difficult for me to come. I come from outstation. If inconvenient,
So that you'll have to
I will
make an application.
I'll take steps. Yes.
Because it is for the bench who's taking up to
Yes.
consider that.
Wait, please, Your Honor.
The procedure, I don't know, you can ask. for him.
I will. I
Deeply obliged.
deeply obliged.
Wait, please, Your Honor. My lord, in respect to item number 15, my lord, due to my lord non-forwarding the my lord Zimma report, lordship is my lord, directed the I to person affairs, lordship. Just now, my lord, we have received the report, my lord.
From the other side, the petition
Can it
is
be
behind him.
on Monday, lordship?
No.
Whether she will be available or not, I do not have her contact number,
No, the phone number will be there in the file.
my lord.
Just
I'll try to contact her
try to
at 2 p.m., my lord.
You recall that order since he has bought the record.
Just after passing the order, we have received the report. My lord, in this case, my lord, search is submitted, my lord. So, my
Charge
lord,
is submitted.
yes, my lord, search it, my lord, along with the, my lord, says article, it is forwarded to the learned trial court, my lord.
Okay.
But lordship, the person who was arrested along with the drugs, he is already granted bail, lordship, to seizing of the.
No, but once the charge sheet is submitted, you'll have to
Yes.
approach the trial court.
We, earlier we had approached the trial court when the trial was.
So now we'll give you liberty again because now the charge sheet is submitted. When you approach the trial court, then perhaps the charge sheet was not submitted.
Yes, lordship, but it was rejected that as the trial was going on, so the
No.
Zimma was not granted to the owner of the vehicle, lordship. Thereafter, the accused was granted bail. Thereafter, when we moved to the trial court, then it was not at all allowed. They suggested us to approach the higher authority.
When you applied for bail, the charge sheet was already submitted.
No, lordship, means the trial was going on. We applied for the Zimma of the vehicle, lordship. The owner of the vehicle is a different person, not the accused
No, unless the
person.
charge sheet is submitted, the trial will not go on. It will not commence.
No, I'm means telling about 1 year back.
Search
Yes,
is submitted, my lord, in this case, my lord, in the year 2023, October, my lord. It is, my lord.
Where is the rejection order? Let us see that.
The rejection order is. page 17.
Page
It's a page number to go.
Page 17.
17.
It is 23/8, lordship.
That was October.
No, August.
No. This charge sheet was submitted in October.
October.
Correct.
Yes, lordship.
You approach there because
And the
if you
accused,
insist, no, I'll tell you why we are asking you to go there. Because the nature of prayer is for release of the vehicle in Zimma. Now, that is a prayer we'll have to reject. You want to know the reason, we'll tell you. There's already a judgment of this court where it has been held that when a seized article is a subject matter of what you call it's a vehicle or receptacle which is used in crime. It cannot be released in Zimma. I think I forgot Justice Honorable Justice Robin Fugan.
Yes, ma'am.
I think his order.
Yes.
This very explicitly said that at what stage and what items the Zimma can be given. So that's why it would be appropriate if you go there because if you insist on the prayer, then we have no other option but to reject it. And then your options will be closed there also. Correct?
the lordship, one thing I would like to submit, it might be rejected, but when the accused was released on bail, although the charge sheet was submitted in the year 2023 October, Then after the release of the accused person, we again tried to move a Zimma petition
No, we
before
would
trial.
not know. You will not know because you see, when a vehicle is seized under the NDPS Act, these were carrying drugs, right?
Yes, sure.
They can also be a confiscation proceedings. We don't know about it right now. If there's a confiscation proceedings initiated, then we can't do anything about it. And that can be done at any stage. Correct? Heard Miss
Bora.
A. Bora, learned counsel for the petitioner. Next, Mr. R.J. Barwal, learned APP, has submitted that in this case, charge sheet has been submitted on
my lord, to 18/10/2023.
18/10/2023.
By charge sheet number 121/2023.
Okay. Next para, the learned counsel for the petitioner has submitted that earlier the trial court had rejected the bail by order dated 23/8/2023, for which she has approached this court. Next para. As the charge sheet is found to have been submitted after the prayer for bail was rejected by the learned special judge Bongaigaon, court is inclined to close this criminal revision petition with liberty to move the learned trial court with a fresh application for Zimma. Next para. On such application being filed, the previous order of the learned special judge Bongaigaon dated 23/8/2023 shall not come in the way in passing appropriate orders on the Zimma petition in accordance with law. Yes, item 16. Yes, nice. Yes.
What's it? I've not completed.
Achha. What's more? Anything left out?
Yes.
Yes. What is that?
It can be presented. There's a judgment set in the complaint. There is a judgment set in the complaint.
Yes.
Yes, sir. Dayal D'Souza versus Government of India. I've numbered it as a 5.
So there is another.
Yes.
Okay. Yes. Dayal D'Souza.
Number 5.
Yes.
Page 12, para 14.
Yes.
Alert. That the presumptive assertion made in the complaint that the directors of the accused company as such were in charge of and responsible for the conduct of the business of the company at the time of sample was vague. The use of the word as such in the complaint indicates that the complainant has merely presumed that the directors must be guilty because they held the office of the director. The court opined that such presumptive accusation against the directors without any specific averment or criminal attribution being made in the complaint would be insufficient. Now, subparagraph 12. The main clause of the complaint, which is the subject matter of the dispute, is clause 5, which may be extracted thus. The accused number 3 is the manager, accused 2 and accused 4 to 7 are the directors of the company, and as such, they were in charge and responsible for the conduct of the business of the accused at the time of sampling. Now, para 14. Reliance has been placed on the word as such in order to argue that because the complainant does not attribute any criminal responsibility to accused number 4 to 7, except that they were in charge of and responsible for the conduct of the business of the company, it is true that there is no clear abatement of the fact that the directors were really in charge of the manufacture and responsible for the conduct of business, but the word as such indicates that the complainant has merely presumed that directors of the company must be guilty because they are holding a particular office. This argument found favor with the High Court, which was the proceeding against the directors as against the manager. So only presumptive accusation is there in the complaint petition. Page 16 of the same judgment. The primary responsibility is on the complainant to make specific abatement as are required under the law. In the complaint as to make the accused vicariously liable for sustaining the criminal liability, there is no presumption.
You are reading which page, which paragraph?
Page number 16, 39, para number 39.
Page 16.
Page 16, para 39.
Of this judgment.
Of this judgment.
No. Para 39. Okay. Ah,
Right.
yes.
The primary responsibility is on the complainant to make specific abatement as are required under the law in the complaint, so as to make the accused vicariously liable. For sustaining the criminal liability, there is no presumption that every director knows about the transaction. My case is that he has not made the statement regarding that I am looking after the business of the company. And vicarious liability on the part of a person must be pleaded and proved and not inferred. Subpara 4. Page 16.
Yes.
Neither he has pleaded nor he has proved. Another one is Manavendra Ketan Bhai Saab, serial number 4. What's the state of Gujarat? Para number 6.
Para 6.
Para 6.
Yes.
Yes. In the complaint, there are no abatement against the appellants except stating in the title that they are partners of the firm. Learned counsel for the respondent complainant contended that a copy of the partnership deed was also filed, which would show that the appellants were active in the business. No such documents was filed with the complaint and made part thereof. The filing of a partnership deed later is of no consequences for determining the point in issue. Here they have filed some documents which they have not filed along with the complaint petition. So that has no relevancy with the complaint petition. Section 141 does not make all the partners liable for the offense. The criminal liability has been fastened on those who at the time of commission of the offense was in charge of and was responsible for the firm, for the conduct of the business of the firm. These may be sleeping partners who are not required to take part in the business of the firm. They may be ladies or others who may not know anything about the business of the firm. The primary responsibility is on the complainant to make necessary abatement in the complaint so as to make the accused vicariously liable. For fastening the criminal liability, there is no presumption that every partners know about the transaction. The obligation of the appellant to prove that at the time the offense was committed, they were not in charge of and were not responsible to the firm for the conduct of the business of the firm would arise only when first the complainant make necessary abatement in the complaint and establish that fact. So there is a total absence of requisite abatement in the complaint petition.
Yes.
Another one is serial number 7.
Yes.
Siddhartha Mundra versus Steel Traders.
Yes.
Page number 13, para 19. Page number 12. From the above discussion, the following principle emerges. The primary responsibility on the complainant to make specific abatement as are required under the law in the complaint so as to make the accused vicarious liable. For fastening a criminal liability, there is no presumption that every director knows about the transaction. Next one. At the time of commission of offense, there is were in charge of and were responsible for the conduct of the business of the company. So he must plead the mandatory conditions in his complaint petition, which is lacking. Para 22 C, page number 15, same judgment.
23.
Para number 22,
Yes.
subclause C. There are no specific abatement in the complaint as to how and in what manner the petitioner are responsible for the conduct of the business of the company as held by the Honorable Supreme.
Yes.
And one more is Girish Mulsakan versus Enterprise, serial number 8. This is of our High Court.
Paragraph.
Para number 10. Page
Yes.
number 6.
Yes.
No specific role is assigned to the petitioner in the complaint except one omnibus statement to the fact that all the accused directors are liable for issuing the check in question, despite
You are
knowing
in
well
which
that.
paragraph?
Para number 10.
10.
Page number 6.
Yes.
That no specific role is assigned to the petitioners in the complaint, except one omnibus statement to the fact that all the accused directors are liable for issuing the checks in question, despite knowing well that the said checks would be dishonored due to insufficient fund. that none of the directors have exercised any due diligence to prevent the commission of the offense. Now the question before this court is whether the aforesaid abatement made in the complaint against the petitioner are sufficient to fasten vicarious liability upon them. In Pooja Ravinder Devidasani case, it was held that for making a director of a company liable for the offense under section 141 of NI Act, there must be specific abatement against the director, showing as to how and in what manner the directors was responsible for the conduct of the business of the company. Para 12. The petitioner have not issued the check and they have tendered their registration much before the issuance of the said check. Moreover, they were not the managing director of the company. Non-executive director is no doubt a custodian of the governance of the company, but does not involve in day-to-day affairs of running of this business and only monitors the executive activities. To fasten vicarious liability under section 141 of the NI Act on a person at the material time that the person shall have been at the helm of the affairs of the company, one who actively look after day-to-day activities of company and particularly responsible for the conduct of the business. Simply because a person is a director of a company does not make him liable under NI Act. Every person connected with the company will not fall into the ambit of the provision. A director who was not in charge and was not responsible for the conduct of the business of the company at the relevant time will not be liable for an offense under section 141 of the NI Act. Next, para 16. Only a bold statement is made in the complaint against them that they were responsible for day-to-day affairs of the company. There is no specific abatement against them to show as to how and in what manner the petitioner is responsible for the conduct of the business of the company.
Other citations are okay, but this last citation of Girish Mulshankar Chaudhary, I have my reservations. You see, you come to page 1 of that judgment. Name of the first respondent.
Yes.
The cost title. Name of the first respondent.
Girish Mulshankar Chaudhary and others.
Respondent. First respondent.
Yes.
You've seen the name. Come to paragraph 16. Company, is it a company?
This is a partnership firm.
Partnership firm.
Same.
Partnership firm, section 9. What happens to section 9? Just say you have partnership firm, partnership act. Partnership act.
Because, but the same clause applies to the partners also. I'm reading section 141 offense by companies.
No, it's absolutely unacceptable.
Company means any body corporate.
You take this section 9 if I'm not wrong. Nine. You've never considered, nobody pointed it out, even the counsel for the parties never pointed out, and therefore this judgment came. I'm not saying, I'm not commenting on it, but I have some reservations. I have my own reasons. I have some reservation in this, with this judgment.
In section 141, both the company and the
No,
part.
no, 141 doesn't take away the presumption which is already there under section 9.
Yes.
So therefore, when 141 is mentioned, well, this is a subsequent act.
Yes.
This
1989.
act- No. This is a new act. Partnership Act is a new act. And negotiable instrument is act is 1881.
Yes.
Although it is an amendment which brought in later than 1932, but the act is still old. First in point of time. Therefore, when section 9 came in, there is a presumption that the legislature would be otherwise conscious of what is there in that act. But subsequent amendment also, that's why I said I have my reservation. I am not making any comment, but I am trying to tell you that one, what you call, on part of the lawyer, not mentioning about one provision led to this judgment. Statutory presumption can't be said to be a mere presumption. This presumption is statutorily backed.
Subject to correction, in a partnership firm, all the directors are liable for the civil.
In partnership, there is no
All the partners. But for a criminal liability.
I'm not going into that debate, but the issue is that I personally think that at that point of time, maybe the learned counsel could not point out before this honorable court, the bench which was taking it up, was never pointed out that this was not a company, it was a partnership firm. Number two, maybe he was not acquainted with that provision of section 9. I suddenly remembered every time I don't remember. Point out section 9 was again not pointing it out was perhaps a mistake. But it's a judgment, we have to respect it.
Yes.
I'm not saying this makes the judgment incorrect, but I have my reservations. Okay, that's all. That's all, Mr. Kabra.
No.
Yes.
Lordship, regarding the first, I come to page number 49 of the statutory notice, Lordship. Because the submission is in two aspects that to know the transactions. The statutory notice was served
49, yes.
Page number 49, Lordship. To all the partner directors, to the directors and the responsible persons, the notice were sent on 24/5/2013, Lordship. Then demanding the statutory amount, the check amount. Then come to page number 52. The petitioner herein, who says that he has no knowledge and nothing responsibility, who himself on 31/5/2013 give a reply being the authorized of Dimes Ferro Alloys Limited company that he will make the payment in 2 installment.
52.
Yes, page number 52, you kindly see.
Yes.
This is annexed with the complaint petitions. This is here in part and parcel.
Yes.
That reply, he was sent also to me, my advocate. The notice was sent to be the complaint and me also. This is to inform our factory located so and so is shut down. Position due to which we have delayed the payments for almost all credits. We assure you of making payment in 2 installments, 10 lakhs each. First installment will be paid on June 2013 20th June 2013, and
Who-
another
who is
payment
the-
will be
who is
made on
the-
20th
Who is the
July.
author of this letter?
You know, with the revision, the petition, it is enclosed. With the
No,
revision,
no. Who is
yes,
the author of this letter?
there's Swet Agarwal, the petitioner, the director of the company. He served this reply that 20 lakhs check amount he will pay in 2 installments. The counsel for the petitioners was submission that he has no knowledge, he is not active partner, a director, transactions. The same is in paragraph 8, page number 28 of the complaint is also mentioned about that. And the same was exhibited. 28 of the complaint petition, paragraph number 8 also. The aforesaid registered notice demanding the payment of the check was sent to the correct address of the accused company and to the accused person. And the accused, after receiving the notice, sent a reply dated so and so, whereby accused person admitted their liability and assured to pay the amount in 2 installments. Mr. First, so and so. Then the 3 lakhs, and the complainant surprised that this time again the accused persons have failed to fulfill their commitment. So page number 52, this is a clear admission that he has due knowledge and he served the reply. So all the judgment that he has no knowledge, he has no role, that part. The complaint case is on a 2013 original complaint. Authorized signatory.
Yes.
And 141 says what? Your Honor? He has full knowledge. 141 says if the person committing an offense under section 130 is a company, every person who at the time of offense was committed was in charge of and was responsible to the company for the conduct of the business of the company, as a company shall be deemed to be guilty of the offense and shall be liable to proceed against the punished accordingly. So he is very much in the company. He responded the transactions. He admitted in 2013 and now 2024. When the complaint is at the stage of statement of defense, he has approached this honorable court. Last 11 years, there was no any crossing petition, nothing.
Yes.
Second, Your Honor, my evidence on affidavit, Your Honor, I have enclosed come to the evidence on affidavit, Your Honor. Affidavit on opposition.
Which page?
Yes, page number 78. Right, first I'm coming to page number 78. The bank witness, Your Honor.
Yes.
where the accused persons company maintaining the bank account, she came in court and deposed. On oath, earlier I was working branch manager SBI Specialized Chorangi SME Kolkata. Presently I am posted manager there at Exhibit 2 my ID card. Bank has furnished original document called for by this time Pharaoh Eloise. Accused company has bank account in Bank SBI Specialized Chorangi Kolkata. Exhibit 5 is the check issued by the director TC Agarwal dated so and so in favor of DRS. Prior to issuance of Exhibit 5, there were 3 numbers of directors: Swet Agarwal, TC Agarwal, and Naresh Kumar Agarwal. She was the bank, whether any information that you are not responsible, he is the director.
Yes.
Then the Exhibit 21, next page, contains total 5 pages of both on front and back, and all 5 pages that 3 directors named have affixed there in the signatures. Exhibit 22 is supplement agreement of loan cum hypothecation, the date of execution of Exhibit 2, so and so, and there is a seal and accused company and signature of Swet Agarwal, the petitioner. Then Exhibit 22, 1, 2, 3, 4 seal of the accused company and signature of Swet Agarwal. Exhibit 23 is the board resolution dated 4/12/2012 of the accused company. And Exhibit 23, 1 and 2 are the seal of the accused company and signature of Swet Agarwal. Exhibit 6 is the computer generated memo of so and so, payment stopped the withdrawal. So now page number 82. Bank brought these documents and they were exhibited. In page number 82, every signature before the bank, letter of arrangement is signature of the petitioner, accused petitioner, 3/12/2012. In the terms and conditions, is also page number 91 with the bank, the signature of the petitioner and photo with 91 page number. He is taking lead. His photo is, he signed all the things. Section 2 post, page number 91. You know? Page number 91. He signed all the documents we related with the bank in respect of the accused company. Annexure K is page number 92. This is supplement agreement of loan 4/12/2012. This is also signed by the accused, representing the bank as director. Below one. And annexure L is page number 95. Authorization letter in the bank. This is board of directors. Dated 4/12/2012. All these documents were made exhibit.
Yes.
Then Lordship, can you see, come to page number 95, board of directors and signature of authorized Swet Agarwal is seen. These were exhibited as exhibit 22, page number 95, 96. Certified to extract from minutes of the meeting of board directors duly convened at which property of quorum was presented 4th December 2012, registered office so and so.
Yes.
Bank manager produce all these documents. If this is 4/12/2012, now come to page number 24, page number 24. Although this honorable court has negated that part, I will come to that part aspect also. Kindly see. The document on the base of which, page number 24, annexure A, out of these two, one document has to be false. The approach is not should be the clean hand. Page number 24, the date is 10/10/2012, he has resigned. It is his submission. In complete his submission, annexure A, he made in the revision petition that he has resigned on 10/10/2012. When he has resigned on 10/10, the how this board of directors 4/12/2012 under his signature will come in the bank. So definitely something is going on. My fraud is committing to either to the bank or the person. 4/12/2012, he submitted a board resolution where there his signature as a director. There is no dispute to that part. Then, Your Honor, there's documents, as you know, said that this is apply 10/10/2000, your design, this is own document. Then we approach the competent person and obtain some documents from the site of Jumba Corporation. By paying fees, we obtain the documents. That you want to come to page number 73 first. 73. Before that, you want to come to page number 69. 69. These documents we obtained from the site Jumba Corporation, www. Jumba Corporation, I made in page number 69. 69 of affidavit in opposition. You got it? Annexure E.
Yes.
Yes, kindly see. 23/4/2016. He made application to the board of directors. That due to my personal reasons, I am unable to maintain the directorship of above mentioned company. So I'm tendering my resignation as director of the mentioned company with immediate effect. This is his signature. This is his 23/4/2016. So this document is false before the honorable court. On the basis of this document only he approached before the court. Entire submissions was or this or that reason, law point, everything. But he has not come to the letter which he issued by that director. Page number 52, he did not come to that. Then, you know, kindly see page number 73. Page number 73, the list.
Yes.
The time ferroalloys below that one, two, three, four, five of directors, 23 June 2004. This is Sweta Agarwal. Page number 73, not?
73, yes.
Yes. 72 is annexure G, that is Sweta Agarwal we obtained. 73.
Yes.
Sweta Agarwal is registered ministry. We obtained the date of appointment, original designation as a director. The company name 1, 2, 3, 4, 5 number. Times Ferroalloys Private Limited. Mega Group, page number 73.
Yes.
No? Got it?
Yes.
Yes. Director, 23 June 2004. Original date of appointment of Sweta Agarwal is a director. And 23/4/2016, date of session.
Yes.
Then you want to come to see page number 74. Can you see? Page number 74, we have developed annexure H. This is Time Ferro Alloys Limited, public limited, upon which we have filed a case. Here what is written? Notice is hereby given to that the members of the company at their extraordinary general meeting held on 6/1/2015 to pass without modification of special resolution for conversion of company Liber Times Ferro Alloys Limited to Times Ferro Alloys Private Limited under the applicable provisions of the Companies Act. Anyone having objection to such conversion may raise in their objection with an affidavit and supporting evidence, if any, with the Register of Companies Act, West Bengal, with a copy of the same to the company register. The register of the company will proceed issuance of certificate of change of name after expired 21 days, so and so. This is under the signature of Sweta Agarwal, petitioner. Sweta Agarwal, can you see this? This is when he is not a director, he taking steps to convert the public limited to the private limited. Everything is in. Under what capacity he has filed this false document 10/10/2012 on affidavit before this honorable court? So my affidavit, I said this is a false document. But the honor first instance that this is your internal part, nothing will happen. You have to show whether the companies. So I obtain all the documents from the company side. This is by paying fees, this document can see. This document which I have annexed before this honorable court, I have obtained.
Which document?
This document annexure A. This is annexure is 69, page number 69 to page number 76. These all documents. There is a site, you know, and I have mentioned in my paragraph number 6, page number 63 also. So resignation was on 23/4/2016. 2015, he made conversion from public limited to private limited under his signature. Resignation letter was also produced before the court after obtaining from the site. But under what capacity he filed this annexure A 10/10/2012, where bank has showed that he is a director, he is making transaction, all these things. Complaint cases of 2013 and page 52, his reply is very much that I will pay your amount. So last 11 years, here and there, this or that region, the matter is kept pending. Yes, 52, he under his signature, he said that he will make the payment. Now before this honorable court, he made submission that that same is not within his knowledge. What I very correctly said, that whether bank was intimated, I have shown that he no, nothing is bank. He is dealing with the bank, taking loan, everything under his signature, everything is doing. Even board of directors letter is given. Is that not a matter of inquiry? That part kindly see 10/10/2000. He has submitted that petition that he has no knowledge. Okay, Without this application, his document, if he comes before this honorable court, I would have no any objection to that part. Now what happened, because of pendency of this matter, learned court below said that no, let the order come from this honorable court, then I will take up, giving that this is matter of 2030, last 11 years for just 20 lakhs. What much interest, what will be achieved by the complainant? Okay. So my humble submissions, one should dismiss this cross petition and stern direction should be given for placing this false document before this honorable court, because this is my submission with all documents I am submitting, with all documents obtained from the site. Any can be verified. I have not manufactured any document. The bank witness also come up. He had adduced everything. And page number 52, entire submission is made before the court. He did not speak a single line to about the 52, page number 52, that Swet Agarwal has admitted that liability. Otherwise, it would be, this matter would be finished within 5 to 10 minutes. He took such a long time by submitting here and there. This is my great objection to his part, Your Honor. He should be, at least we should be clean hands before this honorable court. Only my submission is that part. Okay. Yes. That's all.
Give reply on the law points. Some facts. He is placing para number 8 of his petition, complaint petition, and saying that I have given a letter to him acknowledging the debt, which I have denied. In the complaint petition, he nowhere stated my name that I have issued the letter. The aforesaid registered notice demanding the payment of the check was sent to the correct office address of the accused company and to the accused person. And the accused, after receiving the notice, sent reply dated so and so, whereby the accused person admitted their liability and assured to pay the amount in 2 installments. There is no specific allegation against me. And regarding the document, he is saying that this is a manufactured one. In para 2 of my petition, page number 4.
Yes.
That the petitioner stated that earlier the petitioner was appointed as a director of Times Hero Limited from 2004, and that the petitioner had discharged his duties to the utmost satisfaction of the management of the company till 2010. However, due to the preoccupation of the petitioner in Mega Granules Private Limited, Assam, the petitioner came to Guwahati in August 2010 and was actively looking after the affairs of the Mega Granules Private Limited since 2010. And as the petitioner was unable to devote time to Times Hero Alloys Limited, so the petitioner resigned from the post of directorship on and from 10/10/2012, accordingly communicating the same in writing to the board of directors of the said company, which was duly accepted by the board, and the same was recorded by the registrar of companies later on. I am not disputing that I am not the director of the company. Nowhere I have stated. In my submission, I have not stated that I am not the director of the company. He is saying that I have stated, but nowhere I have stated that I am not the director of the company. He has placed some document before the honorable court. The same documents are not annexed with the complaint petition. All the documents were given first time in his affidavit in reply. No document is annexed with the complaint petition. regarding that, I want to place one judgment. Manavin Ketan Bhai Shah, para 6. The learned counsel for the respondent complainant contended that a copy of a partnership deed was also filed, which would show that the appellants were active in the business. No such document was filed with the complaint or made part thereof. The filing of a partnership deed later on is of no consequence for determining the point in issue. So he has filed a document for the first time before the honorable court. That document are not annexed to the complaint petition, and there is no averment relating to the same in the complaint petition. Yes. My humble submission is, I am not disputing that I am not the director of the company. I filed a letter before the director. They have accepted it, but now my name was the same was accepted later on. I have stated in my petition also. I am not disputing that I am the director of the company. But they have failed to ever regarding the mandatory provision in the complaint petition. And in absence of the same, I am not vicariously liable. I may take part in the company management. That is another thing. But they have to avert that I have the knowledge regarding that transaction against which check was issued. Nowhere in the complaint petition they have stated that you have the knowledge regarding the transaction. I can take part in the company matters in the board meeting. But here the section 141 says that you must plead, and you must plead both the conditions in the complaint petition, which he fails. So I am not vicariously liable. So the proceeding may be cast against me.
Yes.
Decision for the same.
The arguments of Mr. A. Kabra, counsel for the petitioners, as well as Mr. B. Sharma, counsel for the respondent, is concluded. Judge will reserve.
Only one judgment. 2023-10 SCC 545. Because where only said that where the proceeding under 138 of an act had already been commenced with magistrate taking cognizance upon the complainant, and during pendency the company gets dissolved, the signature director cannot escape from the penal liability under section 138.
That's not
Okay,
required.
that
That's
the
not
thing
required.
flags I have placed before this number court everything. Obliged.
That's not required.
Yes, not required. I like it. Yes, number.
Yes.
Yes.
17.
My lord, in this case, my lord, a report was called from my lord that we have received.
Yes.
That report we have received, my lord, that it is.
And Lordship, the petitioner is the registered owner of the vehicle, Lordship, and the same is seized in the month of February. And subsequently, he approached to the learned court below, Lordship, and his prayer was rejected on the basis of the objection made by the IO, Lordship. And the interim order, page number 20.
We visit then. It's not required.
Not required.
Third, Mr. F. Hawk, learned counsel for the petitioner, as well as Mr. R.J. Barwar, honored APP for the state. In connection with seizure of narcotic drugs and psychotropic substances, from the vehicle of the petitioner bearing registration number AS01DT-8861 at Dota Bazaar, DOUTBAZAR. What is the spelling?
DOUTBAZAR.
DOUT.
Yes.
Because in same page 3, you have written 2 spelling. Where is this place? Dot Bazaar, Hatigao.
That is Hatigao area, Lordship.
HATIGAON at Guwahati, comma, the said vehicle was seized in connection with a case registered as Hatigao PS case number 30 of 2024. The said vehicle was also seized. I'm sorry, no, not it. That's right. The petitioner moved the Court of Learned Additional District Judge number 5, Kamrup Metro Guwahati, with a prayer for releasing the said vehicle in the custody of the petitioner. The petitioner claims to be the owner of the said vehicle. The ownership of the petitioner of in respect of the said vehicle is also indicated in the order dated 12/6/2024, passed by the learned Additional District Judge number 5, Counter Metro Guwahati. You see paragraph 5B, after this. However, by the said order dated 12/6/2024, the prayer for custody was rejected. The said order is assailed in this criminal petition filed under section 397/401, read with section 482 CRPC. Next paragraph. By order dated 23/7/2024, the learned AVP was asked to obtain instructions as to whether any confiscation proceeding has been initiated against the seized vehicle. Next paragraph. Accordingly, the learned APP has produced a copy of written instructions dated 13/9/2024 from the issued by one Kuladip KULADIP Mazumdar MAZUNDAR, SI within bracket P, Hatigaon PS, East Police District, City Guwahati. The short contents of the said instructions is quoted below. It is written. 4 lines. Next paragraph. Having heard the learned counsel for both sides, although the court is disinclined to record its finding against the order dated 12/6/2024, which is impugned in this criminal petition, but owing to the specific instructions by the concerned police station that the said vehicle is no longer required for investigation, the court is inclined to grant liberty to the petitioner to move a fresh application for Zimma in respect of the vehicle bearing bearing registration number AS01 DT 8861 before the Concerned Court of Learned, Additional District Judge number 5, Counter Metro Guwahati. Next paragraph. In the event the petitioner approaches the said learned court with a fresh application for Zimmer, it is provided that the learned additional district judge number 5, Kamruk Metro Guwahati, or any other court would be taking up the matter, would pass appropriate orders thereon without being influenced by the order dated 12/6/2024, passed by the learned additional district judge number 5, Kamruk Metro Guwahati, in Misje case number 65 of 2024. Stop with that. The observation has made hearing before. This rule petition stands closed. We are allowing you to move the trial court. This earlier order will not be a bar.
Obliged, Lord. Obliged.
Item 18.
Just add that the instructions produced is retained on the record.
My lord,
Yes.
as per the previous order, the steps has been taken toward for the respondent number 2. My lord, for the day I seek an adjournment. My lord, due to some unforeseen circumstances, my senior Mr. Amit Goel is unable to be present.
Oh, you made a prayer in the morning.
Yes, my
You
lord.
had made it.
Yes,
You are adjourning the matter.
My lord, I am appearing for respondent 2, my lord.
Okay. He is making a prayer for adjournment. Okay. The petitioner, respondent number 1 as well as respondent number 2. You are for 2.
I am for
Are duly represented. What about 3? Notice is served.
Yes, ma'am.
Okay, there is no appearance on behalf of respondent number 3, one whom you notice has been served. Next paragraph. On the prayer made by learned counsel for the petitioner, the matter stands adjourned today. List after
1 week, my lord, next week.
list after a week.
Much obliged.
That's it. Respondent number 3.
You are there. Okay, number 3, your name?
L. Gogoi on behalf of M. Sharma.
L. Gogoi on behalf of Mr. M. Sharma, counsel for respondent number 3. Okay.
Much obliged.
Item 19.
Lordship, here, I'm praying for adjournment, Lordship. Kindly this matter may be adjourned for the day, Lordship.
Have you taken steps?
Lordship, we have taken the steps.
Okay. The learned counsel for the petitioner as well as respondent 2 are present. None appears on call for respondent number 3. Next one, the prayer made by learned counsel for the petitioner, the matter stands adjourned today. List after
3 week, Lordship.
after a week.
Much obliged.
Item 20.
May it please your lordship.
Have you
The
taken steps?
petition is 482 and
Have you
401
taken
of
steps?
CFC, lordship.
Lordship, in that regard, I am for appearing for respondent number 2. We filed a wakalatnama, but we are yet to receive notice or copy of the criminal petition.
Okay.
Copy it. আমি তাইলত গম পাইছিলো এইকাৰণে wakalatnama
Learned counsel for the petitioner and
Respondent number 2.
Respondent number 2.
and the state are duly represented. First one. Mr. Y. Kothari, learned counsel for the respondent number 2 has submitted, that is, you have filed your wakalatnama.
Yes.
He has filed his wakalatnama, which is not on record. First of all, he submits that he has not received a copy of this criminal petition. First of all, Mr. K.R. Bora, learned counsel for the petitioner, shall provide a copy of the criminal petition along with all conclusions to the learned counsel appearing for respondent 3 within 2 days. Next paragraph, list on when
Lordship may fix a convenient date. Lordship may fix a convenient.
list after a week.
Lordship, interim may be continued. Interim dated 24/6/2024.
Okay, interim order passed till this and it's extended till the next date of listing.
High level list.
Deeply appreciated.
It's 21.
May I please, my lord? This is a 482 application. In this application, I am challenging an order dated 16/3/2023 passed by the learned additional and session judge. Now, my lord, in this case, a complaint has been preferred by the DRI for contravention of section 8C of the NDPS Act. Now, my lord, this particular order is not sustainable in facts as well as in law.
Where is the order?
My lord, may kindly come to page 86. This is the order, my lord.
86.
86, page 86. This is annexure 3, my lord. The investigating officer has submitted a charge sheet for an offense under section 8C 20B Roman 2C 22C 29 of the of NDPS Act against the accused person.
You are challenging the cognizance taken.
Oh, my lord, in this case, cognizance is taken. We are challenging this particular order, taking the cognizance. My lord, first illegality, my lord will see the investigating officer has submitted a charge sheet. In this case, no charge sheet has been submitted. In this case, the DRI has preferred a complaint under section 36.
So there's a mistake on the code. It's always a complaint.
Always a complaint.
It's never a charge sheet.
Yes.
Then
And second illegality, my lord, may kindly come to next page. As the accused person, namely Liton Dotto, Kajol Malakar, Jili Ghosh, and Subrata Devnath, are shown absconder, hence they issue warrant of arrest against the absconded accused person. My lord, so far as the complaint is concerned, neither in the CRPC nor in the NDPS Act, there is no provision to show somebody as an absconder. That is point number 1. Even if somebody has been made accused in the complaint, my lord, court directly cannot issue non-bailable warrant against the accused person. There are several judgments passed by the Honorable Apex Court. First, someone has to be issued. My lord. So this is an apparent illegality that has been committed by the trial court. Apart from being that, my lord, there is no prima facie case made out against me. To substantiate that, my lord may kindly come to page.
you see, it's a commercial quantity.
No, my lord, it may be a
No
commercial quantity.
No amount of very good argument would persuade us to quash the complaint at
Yes,
the
ma'am.
initial stage.
Yes, my lord.
It's a matter of trial.
No, it is a matter of trial, my lord, but there is no prima facie case because why am I submitting so before this honorable court? There are 5 accused against whose this complaint has been made. Now the prime accused is
It
my
is
lord,
171 gram. It's a commercial quantity.
my lord, 2,400. 2,400 kg.
2004, ultimately 2004.
Yes, my lord.
There's 2
2,004
kgs.
kgs has been recovered. My lord, they kindly look into what is my involvement in this case. My lord, this is a complaint that has been filed against 5 accused. The prime accused is Gopal Chandra Rai, from whom the entire contraband article has been seized. My lord, before I come to my involvement in this case, I would like to give a brief account of the background of this case. Now, my lord, in this case, what happened? A specific information was received by DRI on 10/9/2022 that some contraband articles are going to be carried on a container track. Well, on the basis of that particular information, they have intercepted a particular vehicle.
You see,
Which-
there was I'll tell you, the rest of the story I'll tell you. There was a truck.
Yes,
In the
my
truck you were traveling,
yes,
and in the truck there was a special cavity. From that cavity, this drugs were found.
yes, my
Yes.
yes, my lord. But thing is that then directly come to what is my involvement in this case. So that's in order to come to that, my lord may kindly come to page 28 first. I'm referring to para C
Oh,
of the petition, my lord.
which page?
Page 28, my lord.
28.
Page 28. My lord may just have a look at it for once.
C, yes.
Yes, my lord, I'm reading the paragraph C. He also stated, my lord, this is the main accused. That is accused number 1. He also stated that the truck needed some minor body repair works for which he was instructed to take the truck to Vishnu Jyoti Bodybuilders near Nirasal Pahar, Lalmati. Accordingly, he started from Umling on 9/9/2022 early morning and entered Vishnu Jyoti Bodybuilder at around 7 a.m. in the morning. He received rupees 15,000 from one Devnath on 10/9/2022 for both repair expenses and his commission for transporting ganja concealed in a secret cavity of the said truck. The said amount was received by him through MS Pandit Traders, Lalmati, Guwahati. My lord, my involvement is that I have paid 15,000 rupees not to the accused number 1, but I have made this payment to one Pandit Traders. He is an authorized agent to make this kind of transactions, my lord. So now I would like to take my lord to page 41. This is the statement made by the proprietor of the Pandit Traders.
Page?
My lord may directly come to page 43. Page 43. I am reading, my lord, para N. Have my lord found page 43 of the petition?
Yes.
On being asked, he stated that on 10/9/2022 at about 17 hours, one person came to his shop, that is MS Pandit Traders, and inquired if he can provide him with the hard cash if a specific amount was transferred to his bank account via online source. Since he is an authorized to make such transaction, he agreed to do so. Then he asked him how was he going to send the money from via online source via UPI ID and the RTG, to which he said he will source his money through GPay. Accordingly, he took his mobile number registered in the Google Pay and called one person and gave him his number registered in Google Pay. Thereafter, as verification, he received rupees 1,000 from UPI ID so-and-so, and he received 14,200 rupees mobile from the same ID. He got the person who came to his shop an amount of rupees 15,000 as hard cash and made a recharge Airtel mobile by remaining to 200. He do not remember the mobile number which he recharged, and the said number cannot be traced out from the recharge detail in his mobile, as an application saves recharge mobile number for only 30 days. He had received the above mentioned amount from one person, Jhilik Ghosh. Now, my lord, Jhilik Ghosh is the accused number 4 and Devnath is the accused number 5. So, my lord, the payment has been made by us to one Pretax Pandit. He is the proprietor of Pandit Traders. Then, my lord, may kindly come to page 45. My lord, these transactions were not confirmed even by the investigating agency. My lord, may once may come to page 45. On receipt this information, my lord, DRI has also
See,
issued.
you are a resident of not
West Bengal,
not 24 Pargana, West Bengal.
Yes, my lord.
You send money to
Pandit Traders.
somebody who's where?
Pandit Traders.
Where is he?
My lord, he is having his office in of his shop, my lord. He is having his shop at
Well, wherever he is, but he sends that money to someone at.
It is Behorbari, man. He is having his shop at Behorbari area.
In Guwahati.
In Guwahati, man.
And then the money is transferred to this bodybuilder at.
No, money has not been transferred to bodybuilder, man. money has been transferred to Pandit traders. Pandit traders gave that money to the accused number 1, who is the Gopal Sundarai. Thereafter, he made the payment to the bodybuilders. And if my lord come to the page 45, it is confined by the Axis Bank, they could not verify these transactions. Even on the basis of unverified transaction, how can somebody be made accused in the complaint, my lord, when the nature of allegation is so grave? And if my lord may come, LCR has been called for, my lord, in this case. Now, entire transaction allegedly has been done from the Axis Bank. But if my lord see the list of witness, which is available in the LCR, the no witnesses from Axis Bank has been made in this case, my lord. So basically,
Can that amount be of inquiry be made in a questioning application?
yes, my lord, that this can be there.
Who is a witness, who is not a witness?
No, my lord, if no officials from the Axis Bank has been made witness in this case, how this is going to prove that the money has been sent by me through my Axis Bank account
That I
to one
possibly
Pandit
can't answer.
traders?
That
My lord,
possibly I can't answer. I'll answer that after the trial is over. You ask me, then I'll see the record and I'll tell you how he has proved it.
My lord, let us have this matter then on Tuesday.
No, we are hearing it.
Deeply obliged. Now, at this stage, my lord, what is required that the prosecuting agency must be able to establish a prima facie case. And in order to prove that prima facie case, some shifting of evidence can be done by the court. I'm not saying that this honorable court at this stage is liable to do weighting and balancing of the evidence. My lord, there is no prima facie case against me. Only because some transaction has been made and some money has been allegedly made to one of the accused person, how can I be held for transporting ganja from one place to another, my lord? Other than this, my lord, I do not see.
Well, you see, I just ask you a simple question.
Yes, my lord.
Nowadays, everybody through the mobile can transfer money.
Yes, my lord.
Any Tom, Dick and Harry can do it.
Hmm.
But if somebody comes to you and asks you to send money to some unknown person, will you do it?
No, my lord, that is the question. If it is being proved through the Axis Bank that the money has been transferred, my lord, this has not been confirmed.
We are now examining merely because only if the complaint at its face value indicates commission of any offense.
Yes, my lord.
How and what is the evidence? That is something which we are not required to.
Now, if my lord is to determine on the face value whether the offense has been made or whether I'm indirectly connected to the offense of the NDPS Act, first of all, my lord, the contraband article has.
There are some reported cases of how elaborate deception is carried out when the money is transferred from one place to other. There are reported judgments.
No, there may be some reported judgment, my lord. Every case has to be substituted by its own
The amount of hands will change.
Yes, my lord.
By the time the money of A goes to B.
Yes, my lord.
PMLA cases you have seen, you have read it.
My lord, there are some judgment which I have read, my lord.
So there's an elaborate deception when the money is transferred under
My lord, in
PMLA.
this case, one fact is sure that I do not have any direct involvement with the crime. But I have been made accused by invoking section 29 of the NDPS Act, which deals with the criminal conspiracy, my lord. Now, in order to establish a criminal conspiracy, there has to be first, prosecution needs to establish an agreement between me and the main accused, my lord. There is no agreement proof in this case other than these transactions, my lord. Even these transactions were not been confirmed by the investigating agency. My lord, their grievance is that, my lord, they have claimed they have sent a summon under section 67 to me, and subsequently I did not appear before the investigating officer. My lord, the real fact is that I never received that summon, my lord. The prosecuting agency cannot establish this.
Substance of it, this you need some protection when you appear before the trial.
Yes, my lord.
Okay. Yes.
That is the only relief which I sought, my lord. I am ready to appear before the trial court.
Okay.
My lord, thing is that, my lord, it was statement of the accused.
Now let him appear before the trial court. Let him be.
But there's not only the 15,000 transaction, my lord. There was a vehicle, my lord, which involved. The West Bengal registration vehicle. That vehicle at the time of purchase, my lord, the 2 lakh amount was transferred to.
All right.
Some substance is that he wants to appear before the trial court.
Yes,
He
my
should
lord.
always
We
abscond.
want to appear before the trial court.
When he appears We give him protection till then. When he appears, the trial court will take care of him. But again, Mr. You see, there's again some difficulty here.
Yes, sir. My lord, otherwise, the order itself is
No,
illegal.
there's some difficulty here.
Yes, my lord.
You see, in a criminal petition, we have got restrictions to give an order of bail.
Yes, my lord. My lord, under 482, the court is having ample power to give adequate direction.
There are not one, there are many hundreds of judgments.
Yes, my
Authored even by me.
because
One
there
drop
are
in the
three-
ocean is also by me.
Yes, my lord.
You prefer an interrogatory application for bail in this application. We'll consider it.
Deeply obliged.
If that is the protection we give you, that protection, and we close this matter. Of course, easy way out. Mr. B. Deckard and counsel for the petitioner. Praise for leave to file an interrogatory application in connection with this criminal petition for bail. He submits that the petitioner has been declared as an absconder in the complaint filed by the DRI. And he is shown as absconder without any issuance of prior summons. Mr.
MK Boro.
MK Boro, then standing counsel for the DRI is present. Next part, on the prayer made by Learned Counsel for the petitioner, common leave is granted to file an interrogatory application for interrogatory application and or bail application in connection with this criminal petition. Mr. This is the matter on such interrogatory application and or bail application being filed.
My lord, is it possible to make this matter part heard, my lord?
No. Part is something. You know how many determinations have been taken up.
Deeply obliged.
Yesterday I was in foreign.
Deeply
Now I'm with you in.
I'm absolutely fine with that. My lord, we shall file an interrogatory application for the.
All right, we'll take that.
Deeply obliged by.
Item 23.
My lord, bail application, I am in jail for 80 days and a section involved with 302 by 34. I am not on merit, my lord, on the period of detention. Already 80 days, my lord, and
how many days? 80?
80.
81 days, well.
81.
81 is contributed to me.
Yes, granted bail.
No, my lord, I have a strong objection, my lord, because there are sufficient materials, my lord.
Yes.
My lord, is my accused person, my lord, along with the wife of the deceased, my lord. They killed the, my lord, husband. And it was done, my lord, in front of their minor children, my lord. They have given statement, my lord. They have seen their father's death, my lord. And there are all, my lord, materials collected against, my lord, both the accused person, my lord, both of them were arrested, my lord. So still there are 9 days, my lord. We'll send back the case there, my lord. Search sheet, probably search sheet will be submitted, my lord.
But charge sheet today has not been submitted.
No, my lord, it is
only for
so
that
this case diary was called from, my lord, that is why.
No, you see, if he can't produce the case diary for some reason, he could have sent the scanned copies of the case diary. You see, this is a practice we can't permit. The IO, in order to file a charge sheet, can't withhold the case diary from us. It amounts to insubordination and disobedience of the order of the court.
No,
We
what I,
can't permit that. He could have sent the case diary and asked it for return.
no, case diary we have received, my
Hmm?
case diary is
Then it's okay.
case diary is received, my lord. That is why, my lord, I am sorry.
Then it's okay.
There are
Look
sufficient
at the
materials
case diary and
collected.
pass it.
My lord, now for the purpose of investigation, my lord, my custodial detention is no longer required. My lord. If you are already in, whether if in whether for the purpose of investigation, if required, my lord, they can put me in behind the bar, my lord. But the concept of the bail is this, my lord, 439, my lord.
Well, considering the gravity of the offense, my lord.
Gravity of the offense, there cannot be a ground for, my lord, rejection of the bail, my lord.
No.
And
That is the
investigation,
NDPS laws of judgment, my lord.
FPP is permitted to make that submission to reject the bail on
My
that
lord.
ground.
and investigation, my lord, all my lord materials collected, my lord. Only, my lord, will send back the case diary, my lord, to file, my lord, search it, my lord.
Let us see the case diary.
My lord.
Please mark the statement of the manner you said.
Yes,
were
yes, my lord.
examined. Mr. Barwa,
My lord.
in fact, I was complimented. This is the first case diary where I have seen the appropriate steps was taken by the police. In fact, a well-prepared case diary. Where can I find this inquest report? I am not getting.
It is there, my lord. Only one of the FSL report of the Visara, my lord, that is FSL report of the Visara, that is pending, my lord.
No, it's come.
I'm
Is there in the case
overlooked.
diary? Huh?
But blood stain report, DNA, that has come, my lord.
No, Viscera report is also there. There's no poison.
I have overlooked.
Huh?
No poison in there.
That's why I said as the one of the this is this is that report. Oh, not Viscera. This is the DNA sample. DNA sample.
DNA.
No, Viscera is not there. You are right. Where is that the inquest? Let us. Can you find out the inquest?
Oh, my lord.
Lordship, kindly see 2012 1 SCC, page 40.
2000?
2012 1 SCC, page 40.
1 SCC, page
40. Sanjay Chandra versus what of CBI versus CBI.
Yes.
That's why I am not on merit, my lord. I was on the period of detention.
Introduce.
Person who has done the inquest requires more,
My lord.
requires some brushing up. He must be trained well. person who's done this inquest does not know how to do it. I'll examine it and pass orders.
My lord, your floor. Deputy.
Because when you compare this postmortem report and the inquest report, it appears that the person does not know how to do it. That's the only.
Deputy.
Procedural, you retain the case there. Procedural, retain the case there.
Yes, we'll give it to you.
My man.
I just have to, because otherwise I would be spending time here.
My lord, my
You'll get it by 5 o'clock. We'll release the case diary.
my lord.
Mr. TJ Mantha, along with Mr. R. Sharma for the petition and Mr. R. Barwa.
My lord.
Yes, bail application.
May I please your lordship?
Yes.
483 application. Lordship, as of today, 79 days behind the bar.
79.
Yes, lordship.
But still we'll have to refuse you. The bail has to be refused again. In English, we call something called incorrigible. She was earlier also arrested for FICN.
Yes.
And again for the second time.
Second time, my lord.
Earlier, she was arrested.
I don't know. I can't recollect where I've read, but I've read somewhere here. She was arrested for the second time. Earlier also you were arrested.
Earlier case was registered under section 120B, 420, 468 and 471.
Yeah, but it was, yeah, I've read somewhere, but if you ask me to recollect.
If lordship may come to the FIR once, as per the specific
No,
information.
I must have read it somewhere. Yes, paragraph page 3, paragraph 2. During time of search, found that the suspected women, Nara Begum, who had previously arrested for possession of instrument for counterfeit currency notes by Biswanath Charity Police Station, found black polythene bag containing suspected fake Indian notes of 3,50,500.
Lordship, earlier case, as it is stated in the FIR, lordship.
We don't know. I told you I've read somewhere. I won't be able to locate it, but I've been able to locate it. This is your statement. We can't allow you. Even if there is nothing in the case diary, we can't allow you.
Earlier,
You have to wait for 90 days.
Lordship, earlier case was not FICN case. It was.
You see, it's your petition. You have written it. I am just reading it.
Even, my lord, in her 161 statement also, my lord, she has stated.
Also, the information that the investigating officer received and they proceeded toward the place, that information was about another woman that is named as Anamika, and it is also reflected in the
That is
FIR.
okay, but somebody is arrested. They may be, you see, every day I write orders. Correct. Every day you tell your names. Every day I forget.
It is there in the FIR also.
I have a very weak memory. I can't remember. So maybe information of X and Y was arrested and Y was previously found with fake currency notes. It's as simple as that.
So, as he was traveling in a commercial vehicle, lordship, that particular bag was there, and the
seat at the time of trial.
officer. So kindly.
Yes, what is there in the case diary?
Well, it is recovered and says from her position, my lord. And in her, although I'm not supposed to, my lord, rely on her statement, my lord. In her statement also she stated also, while I coming back from the, my lord,
statement is okay.
Case, my lord.
That is a confessional statement.
No, my lord, no, I'm not relying her regarding this. I'm relying on that my lord, he was starting from the earlier case, my lord.
You are Mr. D. Medhi.
D. Medhi, lordship.
Mr. D. Medhi, counsel for the petitioner. As well as Mr. R. Barwa and the APP for the state. Next one. The petitioner was arrested on 27/6/2024 in connection with GINGLA PS case number 54 of 2024 under section page 2. So it's paid for bail under section 483 of BNSS 2023. Next one. Just mark that part in the case diary and give it to. Yes, mark that part in the case diary. One conflict of the petitioner has paid for bail on the account of long detentions. Long custody suffered by the. So don't say detention, no, incarceration. Is diary. First of the learned APP has opposed the prayer for bail and has produced the case diary. Next one, on a perusal of the case diary, it appears that there are sufficient materials to implicate the petitioner of possessing fake Indian currency notes to the extent of rupees 3,50, 500, comprising in 701 fake notes of rupees 500 denomination. As per the contents of the FIR, it appears that the petitioner has previously been arrested for possession of instruments for counterfeit currency notes by Biswanath Sariali Police Station, by case number 167 of 2023. Postal. Under such circumstances, notwithstanding the fact that the petitioner is in custody for last 71 days.
9 days. 9 days, 79 days.
79 days. Who does not find this to be a fit case to releasing the petitioner on his day. So according to the prayer for bail is rejected. His diary is returned.
Obliged.
25.
May please also. It's a regular bail application, offense under section 302 IPC. The deceased is my father-in-law, my lord. There has been some marital discord between me and my wife, so I had gone to bring my wife, and then, my lord, in the course of a quarrel, my lord, scuffle took place. In the scuffle, my father-in-law died, my lord. Now I've been in custody for 87 days, my lord. So I'm praying, my lord, considering the length of detention, my lord. Will may be granted.
Yes.
In this case also, my lord, there are materials, my lord. In fact, there are eyewitness also, my lord. But it is only pending for to collect the postmortem report.
If he's 87 days behind.
Yes, my lord. Only on Monday, my lord, he will complete 90 days.
So one day we want.
Postmortem report must not received, my lord. Today I have inquired from the police station.
Hmm?
Postmortem report not received till today, my lord.
But that's okay.
Otherwise, there are sufficient materials.
Yes. But Mr. S. Nawaz granted consent for the petitioner, as well as Mr. R.J. Barwar and AP for the state. Next one. Petitioner was arrested on
19/6/24.
19/6/2024 in connection with Kajulgaon PS case number 68 of 2024 under section 120B, public 302 IPC. It's paid for regular bail under section 483 of the BNSS of 2023. Next one. The learned APP has produced the case diary and has opposed the prayer for bail. on the ground that the petitioner had gone to the house of his father-in-law and attacked him with the iron rod, leading to his death. It is also submitted that the learned, that the petitioner thereafter fled away. Full stop. On the closure of the case diary, it appears there are sufficient incriminating materials against the petitioner of having attacked his father-in-law with the iron rod. Full stop. It appears that there are also eyewitnesses to the incident who have been examined by the IO. Full stop. Next paragraph. Be that as it may, as the petitioner has already spent 87 days in custody, the court is of the considered opinion that further custodial interrogation of the petitioner may not be required. So accordingly, the court is inclined to grant bail to the petitioner by providing that in the event of his arrest, that on furnishing a bail bond of rupees 1 lakh with 2 surety of like amount, out of which one surety shall offer his of the her landed property as bail, as security for grant of bail. So the bail is granted on the following conditions. There are conditions, you take it from them. Amongst other conditions, make it a condition that the petitioner shall appear before the IO once a month till his personal appearance is dispensed with or charge sheet is submitted, whichever is earlier. Next paragraph. In the event such appearance shall be made within 1st to 7th day of each month. On such appearance, the I shall provide petitioner with a memo of appearance as a proof of his appearance. In the event the petitioner does not appear before the IO within the time granted, this bail shall automatically be sent revoked, and it will be open to the IO to arrest the petitioner. Is there a different application disposed of?
26. 26.
Lordship, the petitioner as on today, 55 days behind the bar. His wife lodged an FIR. Translated copy of the FIR is at page 10, Lordship.
Page 10.
10. There is some serious and very absurd allegation against the husband. They solemnized their marriage on 12th of March this year. They had love relations. After marriage, the informant and the petitioner resided in the rented house of the petitioner at Mazigao, Nodwar, Sonitpur. The petitioner is
Just a
government teacher.
Just a moment.
Yes, Lordship. Case is registered under section 64 of BANS. 64 is rape, 89 is miscarriage without consent, 115
voluntary causing hurt. 351,
315.
351 lordship, criminal intimidation.
You don't know, you have
It
written
is a
315.
new act lordship.
You have written 315 at page 11.
Lordship.
At page 11, you have written 315, not 351.
Page 11. Yes.
You are referring to 351, but you have written 315.
Oh, yes, lordship. It is a typographical error on my part, lordship, maybe.
Okay, 315 is what?
351.
351, what is that?
351, lordship.
What is that? What offense is that?
Yes, lordship. 351, no? 351 is lordship, a criminal intimidation. 351.
Yes, what is there in the case diary?
Not case diary, my lord. As per the my lord, husband statement as well as the victim, my lord, they are not married, my lord. But victim was, he was, my lord, kept in his house, my lord. And she was, my lord, sexually she was abused. Even from the statement of the accused person, my lord, he has stated, but they have not married, my lord.
How many days you are inside?
Lordship, as per my instruction, they had love relations.
No. How many days you are inside?
Okay, as on today, lordship, 55 days. I have been thoroughly interrogated, lordship. And I am a.
With this type of.
At that part, I leave it to your lordship. My submission may be recorded.
Yes.
I am a government teacher, lordship.
Well, that does not impress us. In fact, that is a decision not to grant you bail. So that students in your school, they will not repeat it. Mr. M. Pathak, counsel for the petitioner. And Mr. R.J. Barwar, I'm VP for the state. Next paragraph. Petitioner was arrested on 21/7/2024 in connection with Jammu Guri, JAMU, GURI, PS case number. Find it page 1 and 2, under section so and so. Has paid for regular bail under section 483 CR of the BNSS, 2023. When APP has produced the case diary and has opposed the prayer for bail on the ground that the petitioner is a assistant teacher in a school, he is cohabited with the informant and has sexually abused her and intimidated and left her. You say there was an abortion also.
But that report is not available in the case.
Okay. So my consideration that the informant was residing with the petitioner for more than 2 years. The court is of the considered opinion that further custodial intervention of the petitioner may not be necessary. So accordingly, the despite objection by the non-DPP, the court is inclined to release the petitioner named so and so on bail on furnishing a bail bond of rupees 50,000 with one surety of like amount with the satisfaction of the Chief Judicial Magistrate, satisfaction of
Jamuguri PS case number 93.
No, satisfaction of CGM PO.
CGM.
CGM or Gopur will be SDGM.
It is Lordship, Teshpur, Sonitpur. So, it is Gopur Vishwanath.
No, it will not go there. It is district, this one, Jamuguri PS. You find out which is the concerned court.
CGM, my lord, CGM the test.
But this is Vishwanath district. It should be Gopur.
Jamuguri man.
Lordship, it is CGM Teshpur, Sonitpur, Lordship.
From where you are saying that?
Page number 2. Page number 2.
Lordship, it is at page 15.
Sorry.
15.
It is forwarding, Lordship. Yes, 15.
Okay, Chief Judicial Magistrate, Sonitpur, Tejpur. In the earlier case, what was that to the satisfaction of? In the earlier case, I forgot to write.
There is Kazolgaon, my lord. That will be CGM Sirang, my lord. Sirang district, my lord.
In earlier case, to the satisfaction of? No, not this case. Earlier case.
Item number 25.
Item 25. Item 25 is Chief Judicial Magistrate, Chirang. At Kajulgaon. Huh? In this case, it will be Sonitpur, Tejpur. The bail is granted on following conditions.
My lord, only one condition, my lord, he will not harass the informant, my lord.
Okay. Petitioner shall appear before the IO once a month if his personal appearance is visible or charge sheet is renewed, whichever is renewed. Next part. The petitioner shall not make any attempt to meet or harass the informant. First of all, in the event the petitioner meets or harasses the informant, it would be open to the IO to move the jurisdictional court and apply for cancellation of the
Masul.
Oblige, Lordship.
20,
the conditions will be there. This is additional.
27.
May I please?
Yes.
Actually, it's a 483 application. Which this petitioner is in custody for the last 57 days as on today. The offense alleged is under section 87 of the BMS. It was registered for, it is abduction of a girl. Earlier provision was 366 in IPC. On the last occasion, the public prosecutor, he took time for obtaining the birth certificate, because the girl stated in her 164 that she is 16 years. So whether POCSO will be added or not. So that was they went to ascertain because the birth certificate or any age group document was not there in the case diary. Lordship may see.
Okay, you got any information?
Yes, my lord. As per her statement, my lord, she is 16 years of age, my lord, and when we have inquired from the investigating officer, my lord, after the my lord, incident, when the guard was, my lord, given custody, my lord, after that, they have not cooperated with the investigation. Also. That is why, my lord, section could not be added, my lord, and her birth certificate also could not be collected to ascertain her age, my lord. Or to add. It is a case of POXO, my lord. But question is that, my lord, they have not cooperated, my lord.
If also is not added,
No,
Lordship.
you see, the police can't express helplessness.
Yes.
If there's a offense, police suspect there's an offense including which involves POXO Act, they can get a search warrant from the magistrate and go and search and find it out. Why you need cooperation? Why the police needs cooperation?
No, my lord, they went to the place also, my lord, where address is given,
No,
my
I
lord.
understand. But why does the police require cooperation?
No, not
You know how to
cooperation.
arrest
The
people.
question is that, my lord, they're supposed to, my lord, give the birth
I
certificate.
understand. But you have the power to arrest people.
Yes.
And those people who do not cooperate with the investigation, you can still, even the girl's father, you can arrest. Why not? Why would the girl's father refuse to give you a birth certificate? You can have a search warrant issued. You could have raided the house, found out.
Even, my lord, what I have been informed, my lord, they are not available in the given address.
You were arrested when?
I was arrested on Lordship
1907.
1970.
Today is 57 days, my lord.
When we give some more time to the APP, because this is, if POXO is there, we can't just release you. You say, I'm Ahmed.
Lordship, one submission I want to make, Lordship.
Pardon me?
Yeah, by Monday, Lordship, I will be completing 60 days. If she is above 18 years, Lordship, then I will be.
No, that submission he cannot make, my lord.
So because they have failed to produce the document, Lordship, do you have
Investigation is still going on, man.
60 days time?
Because case of
Case was registered and that is a case of 60 days, Lordship.
pardon me? Seven.
The punishment is may extend to 10 years.
Then also you don't get the benefit. You come to 87, imprisonment for 10 years.
May extend to 10. May extend to 10.
No, it's for 10 years, not may. for 10 years. If it is for 10 years, then under 187, the period is 90 days.
Okay, Lordship, then give them some more time.
We give you one day more time.
Yes, my lord. We'll return the case there, my lord, for some up to date.
Mr. M. Ahmed, counsel for the petitioner, has submitted that the petitioner is in custody, was arrested on
19/7.
19.
He was forwarded on 19/7.
It was forwarded on 19/7/2024 and has spent about how many days?
As on today, 57 days.
57 days in custody. Next, the Mr. R.J. Burwal, the APP, submits that he has received the case diary, which reveals that in her statement, the victim has disclosed her age to be 16 years. It is also submitted that the IO suspects that the victim girl has been sexually assaulted. First on a next para, on a query of the court, the learned APP has submitted that as per instructions received from the IO, the informant and the victim are not cooperating with the IO, and they are not to be found in their home, and accordingly the proof of age of the victim could not be collected. Next para. Court is of the considered opinion that the IO is not powerless to obtain the age proof of the victim, even if the informant or the victim is not cooperating. However, in the event, there are no documents to show that the victim was a minor at the time when the offense was committed. The present bail application shall be considered on the basis of materials available on record. Next para. List again on
my lord, 27, my lord.
Huh?
27, we will send by the case there, my lord.
It's too long.
It is very long. Make it 25th.
25th.
25 September 2024. So the learned APP is at liberty to send back the case diary and to obtain updated case diary.
My lord.
Or scan copy thereof on the next date. You get scan copies if original can't be got.
28.
May please lordships.
Just
It's a 483 application, my lord. In this case, my lord, kindly have a look at page 10, my lord. It's a FIR, my lord. And this FIR has been lost by the husband of the alleged victim lady, my lord. In this case, my lord, the informant is Ojit Boro and alleged victim is Minoti Boro, my lord. And what happened in this case? May I read, my lord, the FIR, my lord?
Yes.
In vernacular, my lord. Kindly say page 10, my lord. Page 10. সন্মানপূৰ্বক নিবেদন এই যে মই টংলা থানাৰ অন্তৰ্গত হাহিনী গাঁৱৰ নিবাসী শ্ৰী অজিত বড়ো আজি 13/8/2024 দিনৰ 2:30 বজাত দিনত
2:30 মোৰ পত্নী শ্ৰীমতী মিনতী বড়ো টংলা চৌমাপাৰা পাৱাৰ হাউচত কৰ্মৰত শাহিনুৰ ইছলাম নামৰ ব্যক্তিজনে মোৰ পত্নীক ফচলাই পাৱাৰ হাউচলৈ লৈ যায় পিছত তেওঁক ধৰ্ষণ কৰে আৰু তাৰ সম্পূৰ্ণ কুকীৰ্তি প্ৰত্যক্ষ কৰে তাতে কৰ্মৰত হাহিনী গাঁৱৰে নিবাসী অতুল বড়োৱে পৰৱৰ্তী সময়ত মোৰ পত্নীক অপহৰণ কৰি লুকুৱাই ৰাখে আৰু অভিযুক্ত নিজেও পলায়ন কৰে that is the my lord allegation my lord in this case what happened my lord this petitioner my lord along with his family members my lord used to stay at my lord Tongla inside the powerhouse campus my lord as he is my lord working as an employee of that powerhouse my lord and the informant along with the my lord this victim lady also stayed nearby the powerhouse my lord and what happened there are some for several years they were staying there they have been staying there my lord and accordingly some good relations developed between the two families my lord and there was regular visits in between the family members of the victim and the my lord petitioner my lord and what happened my lord on the alleged of occurrence my lord at broad daylight my lord at 2:30 p.m. my lord while the petitioner was talking something in front of the gate my lord of the powerhouse then one third person came into the scene my lord that is my lord Atul Boro that is in the affair it is stated the Atul Boro কুকীর্তি প্রত্যক্ষ করে
Just a moment.
yes my lord
I think it is entitled to bail. On the material it appears that is entitled bail.
My lord, but there are eyewitnesses, Lordship.
Yes, I've seen that. You were arrested when?
This 15/8.
8. 1 month. But Mr. As I met and counsel for the participant, as well as Mr. Rajiv Barwar and the APP for the state. Naturally, the petitioner was arrested on 15/8/2024 in connection with Tangla PS case number 54 of 2024 under section 64 within bracket 1 oblique 140 within bracket 3 of BNS 2023 has paid for bail under section 483 BNSS, 2023. Next one. The learned APP has produced the case diary and has opposed the prayer for bail on the ground that there is the petitioner was arrested on an accusation of rape, and there are eyewitnesses to the incident who have been examined by the IO. Next one. Although the case diary reveals sufficient incriminating materials against the petitioner, the purpose of the constitutional opinion that further custodial interrogation of the petitioner may not be necessary in this case. In view of the overall circumstances as portrayed in the case diary. Next paragraph. Be that as it may, the court is inclined to grant bail to the petitioner, namely so and so, by providing that in the event of the on furnishing a bail bond of rupees 50,000 with one surety of like amount to the satisfaction of
CGM Udalguri.
CGM Udalguri. The petitioner have been released. If not wanted in any other case, the bail is granted with the following conditions. One, that the petitioner shall appear before the IO once a month till the charge sheet is submitted or personal appearance is dispensed with. Next part is provided that in the event the petitioner fails to appear before the IO once a month, it will be open to the IO to move the jurisdictional court and apply for cancellation of bail. Next, the petitioner shall not make any attempt to meet the informant or any other family members. And in the event this condition is disobeyed, it will be open to the IO to move the jurisdictional court and pray for cancellation of bail. Case diary is done. Application disposed of.
Obliged, much obliged.
29.
29 my lord, case diary not received today.
Didn't it be there for 26 days, Lordship? As in today?
Is there not received?
Case diary not received today, man.
How much more time?
It's for Hodai PS, my lord. So we will fix it on.
Where's the
20, my lord. 29.
20. Okay.
20 crore.
The both sides are represented. The Mr. R.J. Barwal and APP pays for 1 week's time to produce the case diary.
Lordship, can it be on 15 or on 15 or 15/9?
It may not come. It is already 13th.
13.
We are fixing it on 20. So prayer is allowed. List the matter on 20 September 2024 for production of case diary. Obliged.
RT.
May I please the Lordship? Lordship, 4 pieces of fat gold were recovered, Lordship, from my vehicle, Lordship. That was the allegation, Lordship. And as on that, Lordship, 57 days behind the custody, Lordship.
57.
57 days, Lordship. Lordship will come to page number 12, Lordship. Round the reason of arrest. Page number 12. Page number 12, Lordship, reason of arrest, point number 7, Lordship. Main day of sitting, Lordship, 318 of BNF, Lordship.
Yes, their involvement is there.
My lord, it is 4 numbers of both lordship of fake gold, my lord. It was recovered and seized, my lord. And after that, lordship, on the basis of his statement, some other accused person also arrested, lordship, from whose possession, my lord, FICN was recovered, my lord. FICN, fake Indian currency note was also recovered, my lord.
Oh.
From my position, Lordship, only 4 pieces of gold. As on that, Lordship, for 57 days. Sixty days is the mandatory period, Lordship.
One 178 and 179 of BNS has been registered, my lord. But my lord, that may not affect, my lord.
That was based on
178 and 179 of BNS.
That was based
What
on
is that? And the new sections, I have some difficulty remembering it.
Lordship.
What is that?
That is, my lord, counterfeiting, coin, government
counterfeit,
stamps, currency note and bank note, my lord.
The currency note will not come here.
My lord, that is, my lord.
Currency note doesn't come here.
Regarding my lord, 3184 and 3162 will come. My lord. That is, my lord, forgery and sitting.
Well, I have my own reasons to disagree with you. Somebody must have been deceived. Let us say I'm carrying this this instrument, which may be fake. How does it make it an offense?
Yes.
Open, my lord, for what purpose, my lord? 4 numbers of, my lord, for
That we don't know.
both, my lord, of.
That we don't know. That is for your IO to find out.
They used to, my lord, sit people, my lord.
No, we are still not inclined to give you bail. This time when I'm rejecting it, will create a lot of difficulty with the council. The order which I am going to pass will create a lot of problem with the council. All the council in this court would be affected. You know what you have done? I have strange ideas in my mind. I sometimes implement it. The phone number given at page 6 of the petitioner is a incorrect number. The true caller gives a different identity. You have your mobile, check it the true caller. Check it with any other app you have. You are giving a false identity.
Which one? Affidavit.
Page 6 I have said. What is that you know? Phone number is given there.
Affidavit, Lordship.
Yes.
Yes.
That the phone number given is not of the petitioner.
His son, Lordship.
Sabayur Alam. That is not his phone number. It tracks to a different person.
A phone number, Lordship. His family member.
Yes, phone number.
His family member, Lordship. Family phone number, Lordship.
Family member. Again, you are wrong. I'll ask the police to make an inquiry.
Lordship.
You see this, you check up with you have a phone,
Yes, my lord.
check up with Truecaller.
The true caller, I don't know.
You don't have. You check it up. Somebody must be having it.
Phone number to put phone number to
You check this phone number. 868 38 245766. I'll ask the police to make an inquiry.
Lordship, I can remember now. This phone number belongs to their original advocate, Lordship, who appeared there in district court.
That we don't know. This is not be asked.
Lordship,
So once it is there, now not only we reject it,
Lordship.
we send it for inquiry to the police. Let an FIR be lodged with the Lattersil police station.
Lordship, I'm sorry for that because Lordship, this
No,
phone
no, you
number
don't be,
belongs
please
to
don't
their
be sorry.
advocate.
You
His
don't
name
be
is
sorry. I told you, I have strange ideas. At times I implement it.
Lordship.
It's not my business, but I did it. Something
Lordship,
struck my mind.
Phone number generally used to give Lordship their referral
We
person.
don't know
Lordship.
that. We have a rule. We ask the petitioner who files it to give his phone number. You give a fake number. Now the matter goes to the police. We
Lordship.
don't do anything. We dismiss your petition, this bail petition on that ground and send the matter for inquiry. The registry shall lodge an FIR, and all those connected with giving of false information before the court shall be taken care of.
Lordship, I'm sorry for that, Lordship, because
Please
this
don't
phone-
be sorry.
Lordship.
This is something which is not excusable.
Lordship, sometimes happens his son's phone number is
Very
still
good.
available with me,
We'll
Lordship.
teach you a lesson.
Lordship.
We'll teach you a lesson. Sometime it happens. Let us see. It should not happen. What is sometime it happens? You think the affidavit is so disbelievable? That's why I said what I'm trying to do will affect all the lawyers.
Lordship, if I
Please.
allow Lordship,
Absolutely no. You can't do anything with an affidavit. You can't tinker with it.
Lordship.
I have strange ideas.
phone
And
number-
you know, when the matters comes before the bench, I always keep my tab ready. Internet is something I love doing it.
Lordship, he is also an advocate, Lordship. He appeared, Lordship, with the
He will teach him a lesson. If he's a lawyer, we'll send it to the bar council. We'll send it to the bar council. We'll see that he's defrocked. Defrocking is unveiling of the uniform.
Lordship. Otherwise, Lordship, I want to clarify one thing, Lordship.
We don't need a clarification from you.
Lordship, just
We
for-
don't need a clarification from you. You are stopped from making any more submissions.
Lordship, his affidavit person, his phone number is still available with me, Lordship. But this phone number,
Please,
unfortunately,
I'm
this
not
phone
hearing
number-
you.
Yes, Lordship.
For people who are party to a fraud is not to be heard. It's nothing but fraud. And I don't, you see, I sit in the court with a smile. I want to go back home with a smile. I want to live my life very peacefully. And these are something which disturbs me. When we ask you an affidavit, make a true statement, make it. Otherwise, we'll make your life miserable.
Lordship, I can find one IA also, Lordship.
We don't know.
Providing that for
You do
correct
whatever
phone
you
number
want.
of son, Lordship.
But this inquiry will be made by the police. We can't stop it. And nobody will stop it. I'll not undo that.
Lordship, I'm sick.
Heard.
Apology, Lordship, for that.
Mr. We don't accept your apology. It's rejected. Heard Mr. M. Rahman, learned counsel for the petitioner. By filing this bail petition under section 483 BNSS, 2023, the petitioner, namely Taibur Rahman, was arrested in connection with Bipuria PS case number so and so on 27/2024 has paid for regular bail. Full stop. According to the High Court rules, there is a requirement that the petitioner who is moving the bail application is required to disclose his phone number. Full stop. On intuition, the court has verified the phone number provided in the affidavit, which is 8638245766, and it is found from the from the internet that the said phone number from search in a search engine of from the internet that the said phone number is of one Basanta Nath, Basantanath. Full stop. Next para. Accordingly, on disclosure of false information in the affidavit, which is supporting the bail application, comma, the bail application is rejected. Next para. The registry shall examine and lodge an FIR before the Latasil police station to make an inquiry as to the incident of providing false phone number in the bail application. Full stop.
Lordship, for a minor mistake, Lordship, I will be badly suffer, Lordship. Please, my humble request, my Lordship.
I am,
Because
see,
Lordship, I'm requesting.
I am
Lordship,
telling
please,
you,
humble
I don't
request,
have a
Lordship.
heart. I am not aggrieved.
Because Lordship,
I am not aggrieved if you go to jail.
Lordship,
I'm absolutely not affected by what is happening.
Lordship.
The fact is that you see, you are caught, your client is caught with a fake gold. It leads to another inquiry which leads to fake Indian currency notes. And when we check the phone number, that is fake. Why should I bother?
Lordship, why should I'm making to Lordship? This advocate's clerk.
Why
Lordship,
should I bother? I
when
am
this
not bothered.
affidavit
You
was
do
filed,
whatever you want, but I am not bothered. I am not affected. And so far as the court proceeding is concerned, its sacrosanct will be maintained by me.
The only phone number, Lordship, because two phone numbers are available, Lordship, that should not be.
You
Lordship.
do whatever you want. I'll not back up. Full stop.
Lordship, one last chance, Lordship.
No.
Because
Do whatever you want.
because
We are
Lordship,
not,
that
you see, a message must go loud and clear. It's not the case of just saying a sorry. It's not a case. We want a disclosure.
Clerk used to prepare all this, Lordship.
Then
Lordship, that was a previous advocate's phone
please
number.
don't
Lordship.
depend on clerk.
Lordship.
Where you are standing, I was standing once.
Lordship.
Correct.
Lordship.
You don't allow, I did not never allowed my clerk to fill up things.
Lordship.
Something which never happened. You perhaps have not seen us working when Mr. Ajay Barua was sitting here as a APP. You have not seen his hard work. We have seen it in the trial court. Extremely hard work. Those days you have not seen.
Then, Lordship, I may be allowed to withdraw this petition, Lordship. I will.
You do whatever you want. We withdraw it, but this order remains. Inquiry will happen. Will not leave it. You want to withdraw, we can change the order. The inquiry part will not go.
Last.
No. This affidavit business will not tolerate. From in respect of an accused who's caught with a fake gold, who's caught with whose associates are caught with fake Indian currency note, and the phone number comes out to be fake.
Why I'm praying? Everything is right in the
I'm
petition.
sorry.
Only phone number.
I'm not
Lordship,
interested.
that by mistake, Lordship.
I am not interested.
Clerk put the phone number of the previous advocate.
You see,
Lordship.
for every story you can tell, I have 10.
Lordship.
I am a very good storyteller. You want to hear stories from me, you just open the court channel and you'll find every day I tell 1 or 2 stories.
Lordship, I want to withdraw this petition, Lordship.
You
I
withdraw
will
this petition,
file-
that's not a
Lordship.
petition, prayer for withdrawal, petition, but the rest of it will remain.
Lordship, with liberty to file a fresh, Lordship. Because
With
otherwise
liberty
he
to
will be
file
deprived,
afresh.
Lordship.
With liberty to file afresh. Okay.
Lordship.
Welcome. 31.
May please, Your Lordship.
Yes.
My Lord, application under section 433.
Give me a moment.
Lordship.
Yes.
Application
Regular
under
bail.
section 483 of BNSS. Lordship.
Yes. You have a case diary?
Yes, my lord, case diary.
What does it say?
Case diary, my lord, the victim, he is accused number 2, Naimuddin, my lord. The accused number 1, my lord, he entered into the house of the victim and tried to commit, my lord, grab her from the back, my lord, and tried to establish physical relationship. At that point of time, the accused number 2, present petitioner, my lord, grabbed her mouth by cloth, my lord. That is the allegation against him. And at that point of time, my lord, the
Just send me the case diary. What is the medical report? I wanted to see the
Yes,
medical
sir.
report. What is that? Of the injured person?
yes, one injury report is also there, and 164 statement.
But we'll have to reject your prayer for bail. There's an assault on the husband of the victim.
Lordship, Lordship may kindly say, the FIR in which I am seeking bail is Lordship at page 9, and that is FIR number 101, Lordship.
Just a moment. Page number?
Page number 9.
Yes.
Page number 9. This is FIR number 101.
101.
100.
Yes.
Yes, Lordship.
Yes.
And Lordship, the accused number 1 of this FIR also lost an FIR, Lordship.
Where is that?
That is page 15, Lordship. That is
15.
registered as 100. Prior to lodging FIR by the informant, the accused number 1 lost this FIR. Page 15, that is FIR number 100.
54.
And this FIR was FIR filed by the
just a moment. Is the case diary of the second case available?
Yes,
100?
well, regarding the, my lord, that case, my lord, CD is not available, my lord. But my lord, from the contents of the FIR, from the 164 statement and injury report, my lord, reflects that, my lord, contents of the, my lord, FIR is true. Otherwise, from 164 statement also, my lord, she is consistent, and my lord, from the injury report reflects that, the, my lord.
No, but there's a cross case.
Yes,
Page
so-
15.
Yes, cross case is there, my lord.
If there's a cross case, then any story can be made.
Yes, sir.
Because this girl, the lady, in fact, is not
Yes, my lord,
assaulted.
that CD is not available.
There is also.
Because all these two are relatives.
Yes.
Both sides are relatives.
Lordship,
it?
regarding
Relative, my lord, that is.
regarding our FIR, Lordship,
No, both people are referring to the to going to graveyard.
yes, Lordship.
That means there's only one person who has been buried in the graveyard.
So many people went to graveyard. The
Victim's
the-
family was not there in the graveyard,
No,
madam.
they
Her
also
house
say-
is near the
near the
graveyard, madam. At that point of time, while the aunt of the deceased person died,
Oh,
so
acha, acha.
all those persons were there in graveyard. From the statement of the accused, it reflects that as that point of time he became trust, and thereafter he came there to the house of the victim for getting water, and then at that point of time this incident, as per the version of the accused. Madam.
But C15,
Yes.
you were arrested when?
on 19, Lordship, 19,
18,
19 forwarded.
It's 1 month in view of the cross case we are granting bail.
Yes, sir.
But you should have told the court to get both the case diaries. You did not ask for, made the prayer for 100.
That was also dictated, Lordship, on that day for both the case diaries, Lordship.
No, it's not there. It's only one case diary is
Might
called
be
because
mentioned one, Lordship, but the honorable
you
court
should have
dictated
verified
for
it. You
both the
see
case.
now. Because if you have made an attempt for rape, then we can't release you.
Lordship, may kindly see page 19. There is a police
It's
inquiry.
okay, but you see, we have not asked for the case diary. The adverse influence against the state can be drawn. You get it within 7 days.
Yes, okay.
Get it a scanned copy.
Yes,
Not-
sir.
Because he has made out a case otherwise.
Yes.
Next week, any date, Lordship.
Next Friday,
Yes.
if you don't get the case diary, you get the scanned copy of the FIR as well as medical. Basically, I'm interested in that medical
Yes, sir.
of that the victim in that case. But this time, I'm seeing counsel for the petitioner. Mr. I forgot your name.
P. Bothago,
P. Bothago, done at APP, has produced the case diary of Manikpur PS case number 101 of 2024. Next, the learned counsel for the petitioner has submitted that annexure 4 to the petition is a prior FIR lodged by the persons in the family of the Who is the accused there?
In FIR number 100.
In 101, who's the accused?
Accused, my lord, the present petitioner is the
Present
accused
petitioner,
101.
accused number 2 lots. Accused number.
What is, give me the names. I don't
Name-
remember the names.
Sir, Shahid Mia Lordship,
Naimuddin is the petitioner.
petitioner. Naimuddin number 2, number 3 Mubarak Ali. Number 4 is Rul Amin. Number 4 Osmia. Number 6 Rashidul Islam. Number 7 Surab Ali. Number
Okay,
8
Shahid Mia is the. They say the accused number 1.
accused number 1.
Accused number 1 in this case has lodged an prior FIR with the officer in charge of Manipur police station, which is registered as Manipur PS case number 100/2024 under section 325/326/506/34 IPC. It is submitted that the subsequent case where the petitioner was arrested is a counterblast. Next paragraph. Having noted that by order dated 6/9/2024, only one case diary was called. The learned APP shall produce the case diary or scanned copy of the case diary of Manipur PS case number 101 of 2024, 100 of 2024, along with injury report, if any available. Next paragraph, this term, next Friday will be 20/9/2024. Next paragraph, the case diary of Manipur PS case number 101 of 2024 shall be retained with the next date of listing. I think I can't take up any other matters. There is already delayed.
The item submitted.
Huh?
The item submitted.
3 items.
It can be.
Okay, just give the name. Who are the, which are the item numbers? Please, the counsel for the petitioners be there. Item numbers.
Item number 33. 33, my lord.
33.
33.
And
C 33, 34, and 35, my lord.
34, 35. Please give the final report numbers. Charge sheet of final report.
Charge sheet, my lord.
Charge sheet.
Item number 33, CS number 153/24, dated 27/8/24.
Okay.
And 34, CS number 140/24, dated 12/8/24. And 35, CS number 52/24, dated 28/24.
Who are the counsel there in these items? Item 33, who is there?
33.
Your name, please?
Mr. Hussain.
Huh?
Yes, Hussain.
S. Hussain. Mr. P. Botapur, APP. Item number 34. We are closing this matters. You will give you liberty to move the trial court.
Yes, Lordship, already appeared before the IO, Lordship.
Huh?
Petitioners are in interim, Lordship, they appeared before the IO, Lordship. 34, I think.
Okay. 34. Your name?
Yes, Alam, Lordship.
S.
Alam.
Alam. For the petitioner. Just add his submission that as per his instructions, the petitioner along with his son.
No, Lordship, brother and nephew.
Brother and
Nephew, Lordship.
nephew have appeared before the IO. Okay. Be that as it may. Huh? Okay. 35, who's there?
Well, I have already mentioned in the morning session, my 35.
Okay.
Yes.
Okay, 35 already passed order. Okay. Yes, any other matters will be off-listed. It will be taken up by the, it will be listed by the registry.
By the registry, my lord.
I'm not fixing a date. Well, this is not my regular bench. That's why. We'll ask them to be listed. Or you can make a mention before the court. I'll dictate in the order that it is left over. Please make a mention and you get a date of convenience for being listed. Okay?
Your lordship, CDs which were here may be retained.
Pardon me?
CDs which were available may be retained.
Yes, will
Okay.
retain.
Okay. Please retain the case
Yes,
diary.
yes.
For positive crime matter could not be dated. Case diary, which are, in which cases case diary are available?
Yes,
Just give this to the courtmaster.
Yes.
In those cases, we'll pass a specific order to retain the case diary.
Yes. My lord, item number 31 already.
Just give it to the
Yes,
courtmaster.
yes, yes.
We'll do it. Any other specific mention anybody wanted to make? Mr. Mahmood is also there. Anything you specifically wanted?
38, but no urgency, it will be listed in normal course.
What we are saying is that we'll, say for positive matter could not be taken up today, it will be rolled over. You make a mention before the court whenever you want.
Yes.
Only case diaries which are available, we'll try to pass orders on that. I'm sorry, it couldn't be helped. Two hearing matters took up more time.